Members, the House is in committee on the Immigration, Fiscal Sustainability and System Integrity Amendment Bill. We first come to Part 1. This is a debate on clauses 4 to 54, amendments relating to system integrity. The question is that Part 1 stand part. Honourable Erica Stanford.
Thank you, Madam Chair, and thank you for inviting me to open the discussions about the bill. And I'm happy to have the opportunity to talk with the House tonight about the proposed changes and how they fit with the government's objectives and how they fit into our objectives around ensuring regulatory systems work well and committing to action against migrant exploitation. We have introduced an amendment bill. It represents a significant step forward. This amendment bill represents a significant step forward in ensuring our immigration system is fit for purpose. The reforms have been shaped by extensive consultation with legal professionals, employers and immigration experts. But more importantly, this bill responds to a couple of very important reviews, the KC review and the Michael Heron KC review that were commissioned under the previous government. In fact, there is a number of things in this bill that were started under the previous government, that work was done, that was good, sensible work that we've carried on with and has resulted in this bill, which is why I think there is broad support across the House for many of the parts, but I look forward to debating the number of points that were raised in second reading speeches yesterday.
Honourable Phil Twyford.
Thank you, Madam Chair. And great to see colleagues here, also bright-eyed and bushy-tailed at 9 o'clock on a Friday morning. We look forward to a very productive committee stage. As I said last night in the second reading, Labor is supporting this bill for two main reasons. We think it does two important things which are significant at this time, and that is that it makes an effort in a number of areas to sort of strengthen and put in place some useful reforms in the immigration system that we think will make the immigration system more effective in dealing with the various challenges that it has, but also it's important at this point, I think, in time, in maintaining public confidence in the system, giving New Zealanders the assurance that through the democratic process they control our borders and that the system is fair and reasonable and in tune with public expectations. Secondly, it strengthens in a number of key areas our adherence to human rights standards through introducing judicial oversight, and particularly in relation to the detention of asylum seekers and in the introduction of electronic monitoring, which in the immigration space is a new thing. There are 9 discrete initiatives in this bill, and it's our intention, Madam Chair, to address all of them, and we want to have a good exchange on all 9 of those. They're all discrete policy initiatives, and they all demand proper scrutiny through this committee stage process. So we'll be wanting to, it's our intention to work through sequentially each of those 9 initiatives and have a good debate and a good exchange on all of them. I wanted to start by in the question about the definition of mass arrivals in clause 5. So clause 5(1)(a), a group of people arriving on board a group of aircraft are a mass arrival group under subsection 1c if the aircraft arrive within the same 24-hour time period. So this is one of the key elements of this bill, expanding this initiative, and the Minister and officials told the committee that it was in response to some changing in international occurrences where there have been cases of people smugglers effectively purchasing seats on commercial aircraft. I don't think we need to kind of rehash the whole mass arrivals legislation that we have now, but it's designed to expand that definition, which hitherto has been based on the idea that people would come on a ship or a boat, and so So we had quite a bit of discussion about that at the Select Committee, and the committee recommended that to clarify that people arriving by air on separate services would need to arrive within a period of 24 hours in order to be captured by the definition. And that was really to avoid a kind of a wide grouping of different disparate aircraft arriving, and somehow that being interpreted to mean a mass arrival. It is worth, I think, digging in a little bit on this question around the definition of a group of aircraft. And I'd be interested to hear from the Minister about how she interprets that and perhaps the official's view. Does that mean a group of aircraft that have come from the same point of embarkation, same country? Does it mean a group of aircraft who where the same people smuggler has booked seats on different aircraft? What precisely does it mean to say a group of aircraft? Or is it a group of aircraft who happen to have come just by definition within this 24-hour time period? So I think that's worth exploring, and I invite the Minister to respond on that.
Madam Chair.
Dr. Lawrence Shunan.
Thank you, Madam Chair. We too want to spend a little bit of time on the committee stage for this bill, because this is quite a technical bill and there are a lot of different parts to it. But I want to start with Clause 4. I want to first start with the definition of first available aircraft. Now, it is good to see that the Education and Workforce Select Committee has included a consideration in there for those who are currently or has applied for either judicial review or a tribunal determination. And I think submitters are rightly to point out that the previous version of having the person having no further right, which is B, is problematic, particularly if someone does have those life applications going through, which will be inconsistent with NZ BORA Section 27, subsection 2. But what I'm interested to know from the Minister is that in this part, it says the person has applied for leave to bring judicial review proceedings within 28 days after being notified. But if you look at the website, and particularly the Ministry of Justice website, it allows for not only the person being notified, but also a representative of the person being notified. Because, for example, when you apply for judicial review, and particularly in these cases, often it won't be just simply the person, but it could be a representative of the person, or a lawyer, or immigration advisor, etc., etc. So I'm curious to know why, despite what is on the Ministry of Justice website, that the bill itself doesn't allow for a representative being notified. So I do want to ask the Minister to consider my amendment, which also includes a representative of the person to also be allowed to be notified, unless the Minister is able to confirm that in AA Roman numeral 1, after being notified, also implies a representative of the person, in which case, everything is covered, that's fine. I want to now speak on to my second amendment and second point, which is still under the definition of first available craft. And now we're looking at under D, which is the deportation or turnaround of the person from New Zealand will not contravene Section 164 of the Principal Act. So 164 essentially talks about limitations on deportation. I want to check with the Minister, if 164 is mentioned, then why is Section 166 not mentioned, which also has limitations on deportation? And in this case, 166 is a limitation on deportation for diplomats. Does that mean that 166, for example, will never be in any instance captured by this bill or by this definition? Again, if the Minister could clarify, that will help, but I do have an amendment in on that, if the Minister wouldn't mind considering. Finally, I now want to discuss the definition of irregular entry into New Zealand, and I have another amendment paper on this. And this is F, which is on the person having assisted to enter by smugglers. Now, I'm hoping that the term assisted implies that the person would have been, I guess, smuggled voluntarily, as in they agreed or has agreed to be assisted by the smuggler. But that wording is vague and potentially could be arguable. So it's just a very simple amendment, which is that the person has been assisted to enter by smugglers willingly, as in it is not involuntary smuggling or, human trafficking. But again, if the minister is able to clarify that, there is an amendment. But if the minister clarified it's satisfactory, then we can leave that amendment. But those are my 3 questions to start with.
Madam Chair.
Ingrid Leary.
Sorry, I'll move over here for my laptop. In the House last night, we had quite a good debate, and I think it's very clear that all sides of the House want to uphold the human rights and liberties of the unfortunate people, the people who are unfortunately find themselves as asylum seekers. And there was a bit of a divide. Interestingly, the National and Labour agreed that this legislation is useful to uphold that, and I think the Greens thought it was a bit of a response to a moral panic situation. But what is very clear is we all want to uphold these human rights, and as the previous speaker has said, much of the devil will be in how this is interpreted in the courts, because these are essentially a system that is put in place to enable quite a hopefully streamlined judicial process so that there is fairness and certainty for the people involved. And that is why it's really, really important that we get the wording right and we don't have unintended consequences. I think this debate may be longer than the government might anticipate, not because we don't agree, but also because there is a 44-page amendment on the table regarding the electronic monitoring. Now, that is a good thing, and I'm really pleased to see that the Minister has responded to the Select Committee, but that will take some analysis, because when we're talking about electronic monitoring or any other form of warrant or detention or judicial review, we've got to get the wording right. So I too now, Madam Chair, will turn to part 4 and raise some other issues that have not been raised. One of them is in terms of section 4, subsection 1.1, where it talks about judicial review, and the reading of subsections 1, 2 and 3 don't quite make sense when read all together. I have not got an amendment on the table, but I'm wondering whether she would be minded to simply strike out subsection 2, applied for leave to bring judicial review proceedings after the prescribed time. It does not seem to add anything, and it actually adds confusion to that paragraph. In terms of the evidence for leave to bring judicial review proceedings, it would be good to know what level of proof is required for that. And there is in subsection 1AA1, when it says or within any further time allowed by the High Court, that looks like a drafting constraint on the ability to take a judicial review, and I find that concerning. I wonder if the Minister could comment on that. Does she see that as a restriction of the rights available to those who would be affected by this clause, and would she be minded to take that out if it meant there was more certainty for that? When we look to the next part, the next question I have is around the words, the identity of the person is unknown, and there are questions about whether that is a justiciable and objective test. And the reason why is it's not very clear. So we don't know if that's somebody who's unable to get documents. What is the threshold of the identity of the person being unknown? Is it an absence of documents? Is it an inconsistency of documents? Is it a failure to be able to get the documents verified by a recognised New Zealand institution such as a district court judge? And does it actually do the words, how do they interact with the Refugee Convention, especially Article 31. So my suggestion, Madam Chair, I haven't had time to do amendments, but I wonder if we could extrapolate that out to something like, instead of saying the identity is unknown, just to suggest that there are 3 elements to that, that there are no documents and or inconsistent documents and or those documents are unable to be verified. It is important because I have had constituents that I've dealt with who have been seeking asylum in New Zealand coming from places like Syria where there is a real question mark over the veracity of documents. We know that they are authentically seeking asylum, but the documents take a while to catch up, so some clarity around that would be really important. I'd like to ask the Minister about the Bill of Rights Act and how any work that she has done, assume Abora was done, but what are her views around how this all interacts with the Section 27 of the Abora regarding the rights to natural justice? Madam Chair.
Ingrid Leary.
Thank you, Madam Chair. And also the processes for enabling access to courts and legal counsel, because if there isn't access to justice, then potentially, even though on the face of it this bill might look like it is upholding the Bora rights, it would be restrictive in terms of liberty rights under Section 22 of the Bill of Rights Act. Section 23 limiting rights on arrest or detention for those seeking asylum. And also there are questions, I'll go to questions now, there are supplementary questions to ones that are raised by Honourable Phil Twyford, and that is the meaning of mass arrival. It's a good intention and it is tricky. One of the questions is a legal question about whether individuals can have their right to be treated individually under the rule of law observed if they are deemed to be in a mass arrival, and that raises issues of legal procedural fairness, such as whether they can get individual legal advice, independent advice, interpreter services where necessary. So what are the safeguards around that? And I do wonder if an easy and elegant way out of that, Madam Chair, again, I don't have an amendment, I'd be prepared to write one, is to simply add a bit of a mens rea element into Section 5, subsection 1A, so that there is a common purpose. If a common purpose is attributed into that clause, I think then we don't have to get into the granular kind of input evaluation of which flights they were on and when they caught them and so on. The very fact that there is a common purpose would capture the mens rea and would enable our officials to be able to do their job for the intended purposes of this Act. It would avoid things like making assumptions about when we're looking at a group arriving on an aircraft, mixed airlines, mixed routes, connecting flights, whether it's from the time they boarded the aircraft, whether it's the time that the aircraft took off, what happens if there's delays. All of those are really prescriptive and tricky. It would just be much better to have a deemed mens rea element in there, and there could be a reasonable element or whatever. I'm sure the drafters would know the best way to do that. The other thing I question is just the fairness about whether planes and boats, they're going to be treated differently, and if so, how does that then interact with the Bill of Rights Act and Section 19, non-discrimination of asylum seekers, because we are now making a discriminatory reference of those who arrive by air versus those who arrive by boat. Has there been some analysis done to make sure that that is in accordance with the Bill of Rights Act? There are some operational things, I think, too, I'm nearly done, Madam Chair, which are just around families being separated. We've got this magic number of 31, and I wonder what unintended consequences there might be if families are trying to separate themselves across different means of transport in order to circumvent the law, if that would be something that we would want to disincentivise because they're already in a traumatic situation, and the idea of children and parents coming in separately worries me. I also worry whether it will discourage people from seeking asylum, And finally, just questions about the operational capacity at our airports. Has any work been done? It's all very well having the legislation here, and I do think it's a good piece of legislation. Do we have confidence that our airports and our staff at airports and our systems at airports will be able to deal with a large number of people coming in? We haven't had to do that before in the circumstance, as far as I'm aware. We had the Tongan case, but I think that those people had already been processed and then were not able to leave, so that's quite different. What impact would there be on airports? So those are my questions just for that first Section 4 and Section 5.
Honourable Erica Stanford.
Madam Chair, I'm just going to take a couple of those. Some of the amendments have only just been handed to me and only just been printed, so I'll deal with those later. But in relation to the definition of a group of flights, and it's pretty clear in the bill, it's just flights arriving within a 24-hour period. There's really no other definition that you need. Have they arrived in the last 24 hours is the definition in the bill. It doesn't matter where they came from, and are there 31 people. In relation to Ingrid Leary's questions, some of them are a little bit out of scope. The definition of a mass arrival is not part of this bill, the overall definition, but the only change is arriving on a flight. And the question about the Bill of Rights, and is it discriminatory, them coming on a flight rather than a vessel or a boat, is an odd question. It doesn't matter how they arrive. I don't think it's got anything to do with the Bill of Rights, which way they arrive. Just in relation to the identity threshold, essentially, if we don't know who they are, then we don't know who they are. It doesn't matter if it is because because the documents are fake or because they don't have documents, for any other reason. Once you start prescribing those things in the legislation, the unintended consequences are that it is too descriptive and we get ourselves all caught up. If we don't know who they are, that is the definition of it, that we're using. And I don't think it's a good idea to start defining in law the types of conditions around whether or not we believe the documents or they don't have documents or anything else. There'll be unintended consequences around that.
Ricardo Menendez-March.
Madam Chair, I'm acknowledging this is my first call, and as the immigration spokesperson for the Green Party, just wanted to first note that one of the things that this bill does is that it does broaden who is liable for deportation, right? So that's also really important to make, even though there are some components that we can critically get behind. It's important to note that this bill isn't about manakiing people who are fleeing horrible conditions, but it also contains some contested components. But I wanted to focus on Clause 4, on the definition of first available craft, which is a new point that hasn't been addressed yet. Now, if I look at the Principal Act, we do have a definition for craft, and that is any form of aircraft, ship, or other vehicle or vessel capable of being intended to be used to transport any person to or from New Zealand, from or to any country outside of New Zealand. Now, the reason why this definition is important in the context of Clause 4 is because effectively it creates a set of conditions for when someone is, the person is liable for deportation, they're able to be put on that first available craft. Now, because craft captures such a broad range of vehicles, I did want to ask the Minister as to why she didn't choose to use the language aircraft. And that is because we've heard a lot of the terms of preparation under this bill. Is the Minister preparing to use other types of vehicles? Currently, for all the constituents that I have dealt with, aircrafts are the primary vehicle in which people end up being deported by. But the language that is used here, first available craft, captures boats, for example. Is the Minister intending to prepare to utilize other forms of vehicles to effectively deport people? And if so, what work is she doing to prepare for that? Or does the system already have capacity to deport people in other forms of crafts other than aircrafts? Because, I recognize that when it comes to the definition of mass arrivals in Clause 5, like we have capture aircrafts as a form of arrival. I know that in the other debates we have had in relationship to the Mass Arrivals Bill, basically we did mostly assume that people will be arriving by boat. But we haven't really interrogated whether the government has any resources to deport people in any form of craft that is not an aircraft, and whether that is even the intention of the minister, because we have used a lot of language in relationship to preparation. I do have some questions more broadly on Clause 8, and I know my colleagues will want to unpack some stuff on Clause 5 as well, and potentially 6. But in the interest of being able to scrutinize this bill adequately, on Clause 8, so this is the amendments to Section 52, and I look at 4A. The minister may, by special direction in relationship to a class or classes of persons holding an temporary entry class visas, impose further conditions on those visas. Now, I know that there's a set of requirements that the minister may need to consider when making those decisions around imposing further conditions. Now, would the minister be able to elucidate the House as to where, in what incidents, would she see the need to impose additional conditions, potentially restrictions, on a group of people? Right? Because we have been told this is about preparation, but I don't think we've received clarity as to the scenarios in which you would need to impose additional conditions on a group of people. And I think that would be particularly important for the minister to clarify, because I know that for other components of the bill, which we'll scrutinize later, you know, the minister and other members of parliament have referenced the horrific attack that happened in Yulin as a justification for some provisions in other parts of the bill. But I don't think a specific example has been used to justify the potential need to impose further conditions on visas for a group of people. And so I am interested to hear the minister's justification for that specific clause. So that's Clause 8, and then specifically 4A. I'm not so much seeking debate on the sort of set of criteria the minister needs to consider, but more about the potential scenarios in which that specific clause would be utilized, and whether there's precedent in which the minister would have liked to have a provision that allowed her to impose further conditions on visas on a group of people that created the need to build in this specific clause. So to recap, I'm interested to know about whether the minister has other types of vehicles and those specific questions.
We don't need the recap. Honourable Phil Twife, oh sorry, Honourable Erica Stanford, I'll come back to you.
I'll get these out of the way as I can, one by one, if I'm able to. In terms of the previous members' questions around craft, there's a long-held definition in the Immigration Act, and it's a long-held definition in the Immigration Act of craft. Usually, of course, we usually put people on the most direct, humane and fastest and first available craft, which is usually an aircraft. But you could imagine that if somebody lived in a Pacific island that needed an airline and then a boat, we would want to do that. So it allows us those options. And so it's a relatively well-used terminology that allows us to do the thing that we need to do to get the person home. In terms of his second question, there's a couple of things that the member was mixing up, I believe, but essentially the ability for the minister to be able to either grant visas or conditions on visas is around special circumstances. And I'll note that when the powers were available under COVID, it was used about 50 times, and since then we've had situations arise like when Vanuatu Airlines got into trouble and we had RSC workers who were stranded here, and we had to individually go and either grant or change conditions on people's visas. Look, if something similar like that happened in the future and we wanted to be able to allow people to stay here, we might have to change the conditions of their visa to allow them to work or to study. It has to be for their benefit, which is the main part of this bill that is very important, that limits the powers of the minister. It has to be in the favour of or not to the detriment of the group of people. But allowing conditions to be altered means that we are able to allow people to do things like go and work if something overseas has happened and they can't get home. The other issue I think he might have been potentially mixing up was the actual person like Samsudeen And what this bill is talking about is making, and there is a condition where with those people we can cancel their residence class visa when they are a threat to national security. So those two things are separate. I'm not sure if that's something the minister, or the member was getting confused or not, but the main important part of this section around the protections and the limited power of the minister is always to make sure that whatever changes are made, conditions are imposed or visas that are granted are in the favour of the people who are being affected.
Honourable Phil Twyford.
I do want to ask some questions about subpart 2, but before I do, I just wanted to go back to clause 5, the amended section 9A on the definition of mass arrivals, and I want to just be absolutely clear, or try to get absolutely clear, that a group of aircraft, in this context, if I heard the minister right, means only that this is more than one aircraft to arrive within the 24-hour period. So they don't need to have any other connection in terms of the people smugglers that might have booked the tickets or the place where they came from. It simply means aircraft that arrived within the 24-hour period. And if the minister's nodding and that's the case. Okay, as a layperson, I would say that is pretty confusing drafting to refer to them as a group of aircraft. They are simply aircraft that arrived within a time period. But anyway, we'll leave that to the courts once this becomes law. So I wanted to just really comment and ask some questions around these new flexible powers that arose out of the COVID experience. Labor supports these provisions, and it's clear that a lot of thought's been put into putting some protections and some guardrails around the use of them, the reporting back to Parliament, the transparency provisions, the requirement that they must only benefit and not disadvantage the people they apply to, and so on. I'm interested in, though, this is a significant power to be conferred on the minister and the government, and so one of the most important guardrails is the definition of the circumstances in which these powers might be used, and the use of the word unusual in subsection 4B A. Now, it's a kind of a paradox because if you make it really broad, then you've got maximum flexibility. The more you define what unusual might mean, the more you limit the potential application of these and therefore defeat the intent. But I would say that in 7.4D3, this becomes almost comical. Where one of the circumstances where these special directions could apply is any circumstance that is outside the department's control. Now, the department is very powerful and controls many things, but to say any circumstance that is outside the department's control pretty much means any circumstance that the universe might offer up. So the effect of that is that there is no limit on the circumstances under which these powers could be used. So I would invite the Minister to share with the House the kinds of... We know some of the historical examples where these powers were used, but what future kinds of situations does the Minister anticipate these powers would be used under, and what does she believe? What does she interpret? How does she interpret the words "any unusual circumstance" in 4BA and 4DA?
Madam Chair. Lamonga Lydia Sosini.
Chair. I really appreciate the call, and I wanted to follow on from the Honourable Phil Twyford in terms of sub-part 2 and the amendments. And the reason why I asked the questions for the Minister is to really understand the whole component around human rights and also the applications that I've seen come through, not just in my office but in the Auckland region where there is many Pacific communities. So Minister, following on from Honourable Phil Twyford, I really wanted to understand firstly the advice that you have received from officials with regards to your flexible powers. One of the reasons I asked, Minister, is because in my office in Māngere, which is a high population of Pacific, we have a range of families and communities who come and talk about their immigration circumstances. And what I wanted to understand, Minister, was the word around the word exceptions. The test that will be used or the advice that you have received, particularly around safeguards. And so sometimes in scenarios where it's, there has been specific events beyond New Zealand's control, but we have had individuals like the volcanic eruption in Tonga, but also some of the RSC workers. And then we have had a scenario where Pacific families have been through the immigration system and they have been successful getting visas, but the temporary visa time has run out. And in some scenarios, there is no person back in that Pacific country. They've gone to immigration to get the tests and what is required to satisfy and justify the request. So I'm asking in terms of the advice that the department has given you, because sometimes when my office or myself has sought advice from immigration officials or the department, not that it's conflicting, but it's different and varying. And for people that are not or may not have a background in tertiary study, and the terms that are used by immigration officials, sometimes there's different understandings. So it'd be really helpful, Minister, if you could explain that. Thank you.
Honourable Minister.
Right. Those questions are all very similar around the types of situations that we expect to happen. And let me run through some examples that were given to me in the advice that I was given. Situations where New Zealanders overseas wish to repatriate their families quickly in response to a conflict, like in the Ukraine. The collapse of Air Vanuatu, which we've already talked about, which stranded the RSC workers here. Education institutes folding, a large labour hire firm going into receivership with serious implications for migrant workers, and of course the volcanic eruption in Tonga. And I think that the member makes a great point in her previous question around the fact that it is very difficult when we have to individually deal with people who then have to go and get information and put visa applications together, and especially if they're running out quite quickly. We don't want people to be here not on a valid visa, and so the ability for us, like the previous government did under COVID, to be able to quickly and swiftly deal with those situations to make sure that those people have valid visas, whether or not we have to extend conditions, change conditions, grant new visas, is what this bill is asking it's asking this House to approve. Now, there are a number of safeguards, and that was the other questions asked by both members. As I've already said, it has to be to the benefit of the people who we are dealing with, but the use of powers would be subject to many safeguards, including the overarching safeguard that they can only be used to their benefit, or at least not their disadvantage. With regard to the special class directions, the Minister would be required to certify that they consider it's reasonably necessary to exercise the relevant power or powers, and that we've consulted appropriately. The class special directions are time limited, they must be published, and they can be challenged by the Regulation Review Committee, and their use must be reported to Parliament each year in the MB annual report. And so there will be a report back to Cabinet in more than 3 years after the powers come into effect to identify whether or not there have been any unintended consequences, and if so, what further legislative adjustments should be made. And so there are a number of safeguards in this to limit the power of the Minister, but as you can see, there are a number of as the member rightly pointed out, situations where we need to act swiftly to the benefit of those people to make sure that they are here on valid visas or conditions suitable for them.
Ricardo Menendez-March.
Madam Chair, just wanted to follow up on an answer that the Minister gave me and appreciate the engagement on that specific question in relationship to crafts. Because she used a very specific example of using a plane and then a boat. But then the boat wouldn't be the first craft, it would be the second craft. And I genuinely ask this because the first available craft would be so broad that I genuinely just want to ask, thus have there been cases in which the first available craft has been anything else other than an aircraft? And as in the first vehicle that people are being put in. My colleague and I worked on an amendment that we've just tabled to, and this is why I wanted to just go back to it, because we just wanted to put an amendment to make sure that the first available craft, so like if people need to be put in a boat or a vehicle afterwards, but that the first available craft isn't anything other than an aircraft. Because I think to me that is really important to clarify in legislation so that if the Minister genuinely intends to say the most humane craft available, that it is an aircraft and not, say, a boat that may not adequately protect the well-being of people or may not contain humane conditions. Now, going back to, I particularly wanted to...
Could I just ask the member to clarify the reason for that question? Because
we just tabled an amendment to strengthen that.
A wide range of circumstances. So could you just flesh that out a little bit as to why?
Why aircraft? Because that's, as far as I'm aware, and this is why I'm seeking the Minister's elucidation, that is currently the only form of vehicle that is currently being used. If the Minister is able to provide examples in which the first point of leaving is being made by anything other than an aircraft, that would be useful. And that is why if the Minister, and we're happy to rescind our amendment, if the Minister can explain why the first point of exit could be made or has been made in the past, recent past, by anything else other than aircraft. Anyway, going back to particularly on clause 8 for DB Roman numeral 2. So this is in relationship to the one that says the Minister considers that the exercise of the power to make special directions in this particular situation will not disadvantage the class or classes of persons to whom it applies. Now, I know that the Minister said that the intent isn't to disadvantage groups of peoples when these now new powers are being made. I know that the Minister used the example of the RSC workers during COVID-19, but can I just confirm with the Minister in relationship to how this is drafted? The language so far says considers, but it's like you could in theory just consider it and then nonetheless move ahead with it. What safeguards are put in place so that it's not just a matter of thinking about it, considering it, as opposed to requiring that it does not disadvantage the class or classes of persons to whom it applies? Because I could see that perhaps not this current Minister, but a future Minister could use the language as written to say, well, I have considered it, I have taken that into consideration, and nonetheless, I'm varying the conditions of a group of people of visas to potentially limit, for example, who they can work for, where they can live, how many times they can come back and forth into the country. And so I wanted to ask about the specificity of the language of consider versus, for example, that those powers must not be used to disadvantage someone, because that's quite a different line of consideration that the Minister would then have to make. So why did the Minister go ahead with consider as opposed to these powers must not disadvantage the class or classes of persons to whom it applies? Because again, as much as I want to believe in good faith that the intent isn't to, can the Minister just clarify how will a future Minister who would seek to restrict or disadvantage groups of migrants can simply just consider it and then go ahead with it and use those powers anyway, since they're not, this doesn't necessarily bind the Minister to not disadvantage a group of migrants?
Madam Chair. Honourable Minister.
Madam Chair, look, in relation to that last part, the member is really grasping at straws. It's very clear it has to be to the benefit of the group of migrants. I've been very clear that there are a number of checks and balances. There is a disallowable instrument, in fact, that it has to be go through Regs Review Committee and can be struck out if there's anything that is not according to the regulations. So I don't think there's anything more to say on that. Going back to the issue of a craft, again, a very minor point. We've not been able to think of any time, and it's not to say there isn't, but my officials can't ever remember a time that the first available craft was not a plane, especially out of New Zealand, because you can't put people on a train out of New Zealand or any. But we don't want to limit ourselves in the case of something that we can't think of right now, but some kind of emergency where we need to use a helicopter, for example. We don't want to limit ourselves, but as far as we can see, that the first available craft has always been an aircraft, but it would be very limiting if we were to use just the aircraft, and then if some other situation came up and we needed to humanely get someone on a craft and that craft was not an aircraft, then that would be very limiting.
Dr. Lawrence Shunan.
Thank you, Madam Chair. I just want to check, unless I haven't heard it, the Minister hasn't responded to my earlier questions regarding my amendments, particularly for the definition of first available craft, but I'm going to move on and just... oh, you did? No. Oh, sorry. The definition is the part which says applied for leave to bring judicial...
No, the number of the number on your amendment.
Oh, the number of my amendment. Okay, it is... Let me just check. It is the amendment that is tabled 84003.
Thank you.
Yeah. Thank you. Apologies. Madam Chair, I just want to check, just to clarify with you, section clause 7, 8, 9, and 10 pertains to 4 different types of visa circumstances, but the drafting itself is largely comparable. So I will be drawing from different clauses from each one because I have an amendment for each of those clauses. So for example, to start with, I want to talk to my amendment, which is around clause 4E, clause 7.4E, clause 8.4E, clause 9.4E, and clause 10.6. Because all of those 4 clauses, the drafting is identical, so my amendment is the same, but therefore 4 different visa classes, if that makes sense. So bear with me. So for 04, it talks about the type of special direction. Now, I want to just check with the Minister because I do think the issue my colleague Ricardo Menendez-March raised is a good one because, for example, in 4D of any of those clauses 7, 8, and 9, you will see that the modal verb must is used. The Minister must certify, not that the Minister certifies. Therefore, if you're looking at clause if you look at clause 4DB that my colleague mentioned, where the Minister considers, or A, the Minister considers, it doesn't have the requirement of must, so it doesn't have that totality. But moving on to my amendment, one of the issues that was brought up is with clause 7.4E, clause 8.4E, clause 9.4E, and clause 10.6.
Which amendment? Sorry, number?
Okay. Let me... Oh, sorry. This is going to take a little while. It's the amendment tabled 84009, 84015, 84021, and 84026. Yeah. So in here, the recommendation is because any decision to issue a special direction under the proposed amendment would be in the absolute discretion of the Minister and would lack the degree of transparency that normally expected of legislation that will affect a large number of individuals. The proposal that I'm having here, but also the proposed power effectively allow Minister to vary otherwise applicable provisions of the Immigration Act itself. My amendments for these 4 sections essentially has a commencement date no less than 28 days after direction is made. Now, rather than saying that commence in accordance with section 378 subsection 3, which is in fact immediately if it's not published. Because I think a default 28 period could sort of intro period will ensure there's adequate notice of any special direction given. I do agree with the Minister that there's a lot of really good safeguards in here, but I just wanted to add a little bit more because of the fact that the secondary or the regulatory making power the Minister has under this bill for these two separate visa classes can be quite substantial and affects a substantial number of people. Now, the second thing I want to mention is my tabled amendment, tabled 84010, 84016, 84022, and 84027. So these are also for Clause 7.4EC, Clause 8.4EC, Clause 9.4EC, and Clause 10.6C. Now, the reason I put in this amendment is that I understand when with B, you can commence. I will finish this call, sorry, Madam Chair. Even if it's not yet published, however, C says it must be published together. Madam Chair?
Dr. Lawrence, you know.
Thank you. I'll be very quick. Must be published together with the explanation of the effect of the special direction, but what isn't there is when that needs to be published. So, for example, in any of these, like 4E, Clause 7, 4ED, for example, it says must specify duration, which can be no longer than 6 months. I like the fact that there is a sunset clause. I think that's a really good safeguard. But for example, does that mean without a specific timing for publication that the Minister could, in fact, publish after the duration or after the special direction is no longer in effect? So my amendments for these 4 parts is just to ensure that while the Minister may consider commencing immediately and delay the publication should still take place within 14 days. So those two are my 2 groups of amendments, but 8 in total.
Honourable Minister.
Right. I'll speak to 2 of Lawrence's amendments just to say we won't be supporting them. 84003. It is inherent that the person includes their agent or representative. And then, oh my God, 84003 we will not be supporting because it's inherent that the person includes their agent or their representative, and that is clear in the legislation. In terms of 84005, you talked about the difference between the diplomatic pathway and not. You can imagine that taking steps to deport diplomats is a very complicated process with lots of concerns, and so we have to deal with those separately, so we won't be supporting that one either. Going back to Ingrid Leary's comments from earlier, would airports have the capacity to manage a mass arrival? Mass arrival group provisions are explicitly to enable people to have access to interpreters and lawyers, and the framework is to ensure the system can manage. That's the whole point of the mass arrivals legislation. If we didn't have that, then we wouldn't be able to cope. And officials have operational planning in place to respond to a mass arrival by air or by sea. Ingrid Leary asked about what is irregular entry. This language is used in the UNHCR guidelines on detention of asylum seekers and is very clear. Then,
point of order.
Answering the questions, but it's really difficult because of the speed and quietness, and for a back and forth I want to be able to digest what you're saying. It's so fast and so quiet. Could we just have a little bit slower, please? It may bring more into the debate, I'm not sure, but this is an appreciation that she is answering the questions and we need to be able to hear the answers.
Okay, so the irregular entry is language used in the UNHCR guidelines on detention of asylum seekers, so it's very clear. She asked, is the bill consistent with the Bill of Rights? Bora, yes, the Ministry of Justice gave a clean vet to the bill, and as I've already said, it's not prohibited. It's not a permitted form of discrimination to distinguish between modes of transport. I already made that clear, but officials have confirmed that as well.
Rachel Boyack.
Thanks, Madam Chair. Now, I do just want to jump forward a little bit in the bill and just recognising that there are probably clauses that I'll be skipping past that other colleagues are going to want to interrogate, but this is a particular piece I'm quite interested in asking the Minister about. So that's Clause 13, which inserts new Section 75A, which is the cancellation of a residence class visa of a person threatening security. So what I note is that this bill does create a power for the Minister to cancel the residence class visas of individuals who pose a threat or risk to security, but who cannot currently be deported. So, for example, there could be substantial grounds for believing that that person would be at risk of persecution, and it then requires the Minister to grant them a temporary visa. This provision, Madam Speaker, arose out of work that was done by the Labor government after the terror attack in a West Auckland supermarket, which happened in September 2021. And that was Ahmed Samsudeen, and he had refugee status and residence, but he had been identified as an extremist and a risk, and he couldn't be deported because of his protected refugee status. What it did was it exposed the lack of tools that a government has in dealing with somebody who is a risk, but also can't be deported because of their protected status under international law. So I have some questions for the Minister on the basis of this, because it does call into question a few, I think, technical challenges and challenges around how this operates in practice. So the first is that it is a significant new power being given to the Minister. And so my question is, why are there not some more accountabilities around it? For example, an appeal right for that person. The affected individual also has no meaningful opportunity to test this information or to appeal against that decision on the basis of the facts or on humanitarian grounds. So there's also a question around, given the seriousness of this, whether it might be wiser to have a judicial warrant as opposed to a decision by the Minister. There's also the situations where someone may be deemed a risk to national security but also has children, and so they have their residence visa cancelled but they have children, and you know, this presents challenges when government really should also be considering what is in the best rights of the children and other family members. And so has the Minister considered the best interests of the child in terms of this particular decision? One of the questions I've got, though, which I think is a really interesting one for the Minister, is that the time frame on this, could a person essentially end up in a state where they were having a continued rollover of a temporary visa? And what rights does that grant them? And then what does the government actually do about the security risk component? So you could envisage a scenario where somebody has their residence class visa cancelled, they continue for the remainder of their life to have a risk of persecution, which means they're not able to be returned to their original country. So that could be 20, 30, 40, 50 years of a person having a continued rollover of a temporary visa. But also, then there's also the challenges to New Zealand's security, which are genuine, because we now have somebody on a temporary visa who doesn't have the rights of a resident to potentially access things like healthcare support that might actually be the type of intervention that's needed to support this person to no longer be a security risk. So I can absolutely appreciate, and we can appreciate as the Labor Party, when somebody, and this particular scenario was an example where real harm was caused and further harm could have been caused. So we're not denying that there is a risk posed by this person, that they've been deemed to be a security risk, but likewise, there's a genuine situation for that person's ability to not be persecuted and potentially killed on return to their home country. So it puts a real conundrum around the situation. So those are my questions for the Minister, just recapping them. Why is there no appeal right? Why not considering a judicial warrant given the significant legal things to consider? What is the scenario when someone has children? What is the scenario when someone has a temporary visa continually rolled over? And then what does that mean for both monitoring that person and provision of support so that they can actually have some potential behavioural change? Thank you.
Honourable Minister.
Chair, look, in relation to those questions, there is the ability of the person to have a judicial review, and that is the process. In terms of where we get a judicial warrant to do this, that is not the case with Immigration New Zealand. It always is the executive power of the Minister in all of these cases. And this is not an unusual situation to have people rolling over on visas, and Honourable Phil Twyford will remember probably as his time as the Minister signing off many rolling visas of people that we are protected people that we can't return, that we will not give residence to. It's a separate it's a sort of a parallel example, but we do that relatively regularly with people that we don't want to give residence to, but we can't return home because they're protected people. This is slightly different in that we are revoking their residence and putting them on rolling visas, but the point is that we will, unless the situation changes in their home country, they will be here with their children and with their family on rolling visas. It is not an unusual situation for us to be doing this, immigration ministers have been doing it for a long time, and that very unenviable situation where we have somebody that has either committed a crime in New Zealand that we do not want to give residence to but we can't return home, or in this new instance where we are revoking someone's residence because they are a threat to security but keeping them rolling over on visas. That has always been the power of the executive and the minister, and it's not been considered to be required to get a judicial warrant. That would be outside of anything that we've ever done in any similar situations, and we won't be doing that. Just going back to Lawrence's questions around the minister's powers to grant visas or to change conditions of visas. As secondary legislation, there's already publication requirements in the legislation publication regulation, so that already exists. Also, Section 378 of the Immigration Act enables the Minister to revoke any special direction if it's no longer needed, and given this is to the benefit of the people who are affected, it will be known to them, and we will be publishing it. We have to. It's a statutory requirement.
Honourable Phil Twyford.
Thank you, Madam Chair. So further to the Minister's responses to the questions from my colleague Rachel Boyack, there's 3 points I wanted to touch on further with this. So the Minister is required under the provisions of this bill to, having revoked the resident visa of someone who's deemed to be a threat to national security, the Minister is required then to issue a temporary visa. Now, if the Minister was to, in that circumstance, issue a visitor visa, the person in question would not have access to paid employment or the kind of income support that they otherwise would be able to get from the state were they on a work visa, or at least not the same level. And the reason I raised this is that I think that would, if the Minister were to do that, to deny the person the potential to have a livelihood and to feed themselves and their family, we would be in serious breach of our international human rights obligations. And yet that scenario, I believe, is open to the Minister under these provisions. So I would ask the Minister to comment on that. What sort of guardrails are there to ensure that if the Minister does issue a temporary visa, what obligation is there on the Minister to ensure that the person in question can sustain a livelihood while they're in New Zealand? Secondly, I wanted to come to to say something about the point that Rachel Boyack raised about this is a sweeping executive power, giving the Minister the right to certify someone. I think it's under Section 163 of the Immigration Act, to certify that someone is a threat to national security. That is a very, if you look at Section 163, you'll see it's a very broad provision. I'm not questioning that it's inappropriate, because I think New Zealanders would expect a minister in this case and the government of the day to be vigilant, protecting the national security of New Zealanders. So that, from my perspective, that's accepted, that's a given. But it is important that in exercising this sweeping power, that there are some safeguards and controls. And I wanted to ask the Minister whether she got advice and whether she considered, well, I know she told Rachel Boyack that she didn't accept or consider the need for a judicial process. But the reason that I think that is worth considering, and my intention is to table an amendment on that in the course of this debate, requiring a judicial process, is I asked the House to cast its mind back to the Ahmed Zawi case, where Ahmed Zawi had his immigration status revoked. He ended up languishing in New Zealand prison for a considerable length of time on the basis of advice from our police and security agencies that was not for a long time not tested in court. And he was not given the opportunity to address and respond to the evidence that was used as the basis of the government's intervention. That evidence was subsequently discredited. And I think that is that the Ahmed Zawi case is a pretty powerful story of why we should think very carefully about enshrining this sweeping power for the Minister of the day to simply certify through secondary legislation that a person is deemed to be a risk to our national security. And I have a third point that I wanted to make that may take a little bit of time, Madam Chair. So this goes to the heart of what this provision is trying to achieve. Everyone, I think, can see that someone is assessed as a threat to national security. They're a protected person under international law, so they cannot be deported. If they weren't protected and they were a threat to national security or they'd committed a crime, they would be deported. But in this case, it puts the government of the day in a very difficult situation. As the Samsudeen... Madam Chair, I haven't finished, Madam Chair. I'm in the middle of my point. Madam Chair. Madam Chair.
Calm down. Honourable Phil Twyford.
Thank you, Madam
You
Chair.
did give me notice that you were going to run out of time, so I was prepared to roll this out.
Thank you. So, what the effect of this bill is it gives the Minister the opportunity to strip someone of their resident status. Now, the question is that intended to be punitive and some kind of deterrent so that it will deter the person in question from staying in New Zealand, for example, because it's harder for them to live because they don't have access to social services and so on, or they then face the possibility that if conditions in their country improve, say, like Syria has, for example, does it mean that they could face being returned to their country of origin, and that acts as a deterrent? So does the Minister see this as essentially punitive, or is it, and has the Minister considered whether or not this is a way of the government of the day having some leverage to sit down with the person in question and work out some sort of deal? Now, the reason I raised this, and I wanted to share an experience that I had as Associate Minister when immigration officials came to me one day and said, there's a person here who is about to be released from prison. They have protected person status. They cannot be deported. They have mental health and addiction issues. They've been in prison for several years, and they were in prison because they committed some pretty serious violence against their family members. And so this was a really difficult conundrum. This person's about to be released into the community. There's no way to keep them incarcerated. And so we had to consider what to do. And after some head scratching and working together, we were able to put together effectively a deal where this person got a temporary visa that enabled them to access income support and social support in return for residential reporting requirements, so they had to check in with their police station, local police station regularly. They had to enrol for rehabilitation services, English language training, dealing with mental health issues, and a pretty concerted effort to try to get this person to rehabilitate themselves. Now, that was a very unusual sort of situation, and I'm glad to report that a year later that person turned up at my electorate office to tell me that they had rehabilitated, had reconciled with their family members, and I know from subsequent contact that that person has done remarkably well and is living happily in the community with their family and is in paid employment and is now speaking English quite well. So, but the reason I raised that is that I'm interested to know whether or not the Minister and her officials see that sort of facilitated community engagement strategy as a possibility, or do they simply see this provision as being punitive and designed to deter someone who's seen as a threat to national security and encourage them to leave the country as soon as possible?
Honourable Erica Stanford.
Madam Chair, I think it's just worth remembering the types of people that we're talking about, and the case that kicked this all off, and under the previous government, the work they did was the Samsudeen case, where there was a threat to national security. The person was under, 24/7 surveillance because of the serious threats to the harm to New Zealanders. It places us in a very difficult position when people are protected and we can't return them home. But what we can do, and I think what the opposition agrees with, is that we can revoke their residency status. And the point of that is so that if things change in their situation, changes in their home country, and at some point they can be returned, we can then deport them. We obviously have to go through a system where we would need to remove their protected person status. But remember, these people are a threat to national security. And let's remember what happened in the Samsudeen case. There is always the option for a judicial review, but this is a practical and pragmatic thing that we can do. So if things change, we are able to remove people from this country. Now, Madam Speaker, the previous minister also talked about the Ahmed Zawi case, and I just want to make very clear that was very, very separate. It was dealt with at the time. There were a number and raft of changes that were made to the Immigration Act at the time around that case to put guardrails in place, special provisions around the use of classified information. That is out of the scope of this bill, but that was dealt with then. So those things are not relevant to this case. This is simply about making sure that someone who is a risk to national security, someone like Samsudeen, if the situation in their home country is to change, then we have the ability to remove them from New Zealand.
Catherine Webb.
I move that debate on this question now close.
Not quite there yet. Lawrence Unan.
Here, I want to be very specific in my contribution, and I want to speak to, I think, 11 of my amendments. I want to start by first going to amendment paper that is tabled. Let me just find it again. Amendment paper that is tabled 840-13 and 840-19. Now, the reason I raised these two, and this is clause 8.4AA and clause 9.4AA, is that it imposes further conditions. I'm recommending that if the minister wouldn't mind considering from impose further conditions to vary conditions. And the reason I say that is the minister has rightfully before say that the minister will consider the exercise of power that benefit class and not disadvantage, but I can't think of an instance where imposing further conditions will actually benefit. Oh, in that case, I will stop there and the minister may be able to respond to that. My next group of amendments is amendment tabled 840-12, 840-13, 840-17, 840-18, 840.23, 840.24, 840.28, and 840.29. Now, these are groups, just again, the Minister would no doubt be aware that I have a special interest when it comes to regulatory making powers and potentially some of the checks and balances that is involved when it comes to regulatory making powers. For both of these two clusters is essentially two main recommendations I want the Minister to consider. And I want to thank the Minister as well for clarifying in terms of the publication requirements. That's very helpful. So what my proposal is, the first one is around that the special direction is not applicable, or Section 378, subsection 8 of the Immigration Act is not applicable to the special direction under various subsection 4A and also subsection 3 of Clause 10. Now, the reason for that is because the absolute discretion that is granted in Section 387, subsection 8 of the Principal Act should not be applied to these special directions. And this will actually help improve the transparency and accountability of decisions made using these new powers and enable those decisions to be more easily reviewed. The second one is to put in a review clause with any regulatory making power. Again, I understand there's a sunset clause, which is fantastic, but I'm seeking the Minister's support on a new clause for each of these, a new clause 4F and a new clause 7 for subclause 7 for clause 10. And this basically is just to allow the Minister or have making sure that the Minister may review the effectiveness of the special directions under Section 4A at any time and must review it no later than 3 years after the commencement date. And now the reason for that is any decisions to issue special direction under the proposed amendment will be the absolute discretion and also like the transparency. The proposed power also allows ministers to vary otherwise applicable provisions. But having this provision in place would just mean that we're able to have some review on that. And noting, I know this is a different section, Madam Chair, but noting that later on we do see in the new 399AC that there is a review clause on secondary legislation on the regulator making power. So even within this one amendment bill, we have seen my amendment being adopted. I want to move on now to clause 18, which we haven't touched on. And this is a really significant section because clause 18 is something that many submitters, including legal experts, has raised to be a serious concern. This is where we are now changing the wording from convicted to convicted or found guilty or pleaded guilty. That's right. Now, this broadens the scope of this particular bill, especially for those who are pleaded guilty but not convicted, i.e. those who are pleaded guilty or even found guilty but are acquitted by a judge are now going to be considered under this clause, which is really, really broad. So just to seek a tiny bit more time from you, Madam Speaker, just for me to finish this one. So we don't really agree that maintaining the status quo undermines the integrity of the immigration system. The court already has the ability to consider, Madam Chair, I'll just finish this amendment. The court already has the ability to consider whether deportation liability should be an appropriate consequence of the offending. And the current framework has to date struck an appropriate balance between the interests of the affected person, the public interest, and the integrity of the immigration system by enabling the court to address low-level crime offendings where appropriate under a well-established sentencing structure. But also noting that if a person is acquitted under this, they're still considered found guilty, which means they're captured under this new clause. The safeguard is provided under Section 206 test of the Immigration Act. A person who is in that situation will not or will unlikely meet the Section 286 test of the Immigration Act. So my proposal and my amendment paper here, and that is amendment paper tabled 84030, is making a recommendation that we keep the status quo of keeping it to convicted and delete the mentioning of found guilty or plead guilty, just so we don't get ourselves into a situation where there is a gap between Section 206 of the Immigration Act and what we already allow people by their right under the Sentencing Act of acquittal.
Madam Chair.
The Honourable Erica Stanford.
Okay, there's a few things there. Firstly, imposing conditions, you asked for an example. If you had a group of people here who are here on visitor visas and their flight or their airline collapsed or something happened in their home country like a volcanic eruption, we would impose a condition that they would be able to work. So it is to the benefit of the... We've been over this a number of times now, and I've already made that clear, but that's one more time I'll make it clear. There is already a review period, as I've already mentioned, built into this. There will be a report back to Cabinet no more than 3 years after the powers come into effect to identify whether there have been any unintended consequences, and if so, whether we need to make further legislative adjustments. So something is already built in to make sure that we are, again, I've mentioned that already. I want to talk, though, about this next part of the bill that the member raised around ensuring that the decisions around deportation stay with immigration. We have a process in immigration whereby if you do something that makes you liable for deportation, there is a process that you go through. It goes to a delegated decision maker. It may end up with the Immigration Protection Tribunal, but there is a process. Circumnavigating that process and is what's happening at the moment, where judges will discharge without conviction to avoid people having to potentially be deported, not actually deported, but just because someone is liable for deportation doesn't necessarily mean they are deported, and in many cases they are not deported. Just have a listen, they are not deported because of the process. So many times if it is a first offence and it is minor and they are liable for deportation, it will go to a delegated decision maker at Immigration New Zealand, and they make the decision on many occasions not to deport. But if they do make the decision to allow deportation to happen, then there are still other avenues for those people to go down, including the Immigration Protection Tribunal and, of course, the Minister. So there is an established system that already exists, but what we are finding that it's happening in the courts is that then there's an argument being made that, oh well, look, this poor person may be deported, not actually will be, but might be, and now that process is being circumnavigated. Now, the first thing is that is not something that is open to a Kiwi. So if a Kiwi was to go before the courts and they don't have the same ability to say, oh well, I need a discharge without conviction because I might be deported, so not available to a New Zealander. Secondly, the types, I just want to give the member, and I mentioned this in Select Committee, the types of cases that we are seeing are things like, and I'll give you an example of one. The person had 2 counts of assault on a person in a family relationship. He punched his pregnant wife in the stomach. The outcome was that the convictions and sentence of 220 hours community service was set aside, discharged without conviction. Now, there is already an established process to work out whether or not someone should be liable for deportation. It sits under the Immigration Act. It always has. It's being circumnavigated. It should sit there. We're being very clear in this instance that if you are guilty or found guilty, or you plead guilty, then the deportation liability will still exist. So what it does is put that process back where it belongs, which is in the established process in immigration through a delegated decision maker, through the Immigration Protection Tribunal, or through the Minister. But it's in our view, in the government's view, which is why we've brought this amendment, it should run through that process and it should not be circumnavigated by a judge who is discharging in these cases, discharging without conviction to avoid the process. Not necessarily, let's be really clear about that, not necessarily deportation. Deportation may not happen, and the judge is circumnavigating effectively that. And we want to make sure that it runs through the same process, the fair and established process that already exists.
Before I take the next call, I'd just like to note, members, please, the scenarios are consuming a huge amount of time. The Committee of the Whole is to see and have issues addressed or questions addressed relating to the bill. So can we just bring it back a little bit tighter to relative questions on the parts in the bill? Ricardo Menendez-March.
Thank you so much, Madam Chair. Yep, and just wanted to clarify to the Chair, one of the reasons in particular Clause 13 why some case studies have been brought forward is that, for example, in Clause 13 we have seen one case study being used.
You are doing it already,
No,
Mr.
but just noting, because what I'm seeking clarification from the Minister is how many people have been deemed to be a threat to security that the Minister would have not been able to strip away residency from, that now she will be able to strip residency from as a result of Clause 13. So I'm seeking actually clarification on how many people would this clause actually seek to capture. And the other question I had was, I would like to seek clarification in the language, because people asking questions and giving answers use the term national security. Now, in this clause and in the Principal Act, the language of national security is not used. It's just security. It's threat to security, not threat to national security. Those are actually quite different things. So can the Minister explain what she would mean by threat to security? Because I do think it's dangerous to use the term national security when that is a term that's used for quite serious things as opposed to threat to security. Now, my other question in relationship to Clause 13 that has not been canvassed is, why did the Minister not choose to include a requirement for her to consider whether the person had received adequate support, for example, mental health support, access to counselling, etc. Because at the end of the day, we know from the examples that the Minister herself has referenced that in those cases, there was a lack of access to mental health support. So I'm interested to know why that wasn't built into Clause 13. Now, on Clause 18, I have also a question in relationship to how many people the Minister currently would be deeming to capture. I'm sure and I hope that she received advice around, for example, how many people on temporary visas would have had been found to be guilty or pleaded guilty but not convicted over, say, the past 10 years. Because I think, to me, this is important for the Minister to clarify to the public what group of population are we talking about. I hate it when the Minister or anyone uses the term "those people." Who do we mean by those people? And it's, I hear the Chair that she doesn't want us to bring examples, but the Minister did just that when in her contributions. She used one quite extreme example of somebody punching a pregnant person, as the justification for this bill. So that is why I'm asking on Clause 18, how many people in the past, for example, 10 years, 5 years, even in the past years, have been found to have been guilty or pleaded guilty, but not convicted and therefore not liable for deportation that she now would like to seek to capture. And what nationalities are more likely, if we take a sample over the past decade, would more likely be captured as a result of Clause 18. Because again, it's simply not good enough for the Minister to use terms like "those people" without telling us exactly the range and the scope of people that would be captured. Surely, when designing Clause 18, she would have said this is a systemic issue, not an issue of one specific example that, that would have not been dealt with. The second question on Clause 18 that I have, because the New Zealand Law Society rightly pointed out that the IPT process can often be insurmountable for people. And so can the Minister give us assurances that she may be exploring additional resourcing to, for example, entities, or advocating for resourcing for entities like community law, to make sure that the potential increase in IPTs being lodged as a result of Clause 18 will be able to be dealt with in a way that doesn't just become this supposed process that people can follow, but actually in practice is completely insurmountable for people to lodge an IPT to be able to challenge the liability of deportation. So I just really want to encourage the Minister to stop using the term those people and give us the numbers of how many people she wishes to capture in clauses 13 and in clauses 18 specifically, so that we're not just actually further marginalising communities. Because Ibrahim Omar, a former Labour MP, rightly pointed out when the attacks in New Lands happened that he did not want to see asylum seekers and or other groups prejudiced by what happened there, and yet we are saying exactly the very same thing under this piece of legislation.
Madam Chair.
Honourable Erica Stenford.
Madam Chair, just in the spirit of speaking more slowly, which I am trying to do, if that member could also just slow it down a bit, take further calls. It's just really hard to keep up, especially when you are merging and mixing two different issues. It is hard. I'm just asking for your to slow down a wee bit and be really clear about the different things you're speaking about, because there were two different things that were merged in here. The first thing was around the case where we have a protected person that we would like to strip of residency because they are a national threat, and you asked about the numbers. Now, at this point in time, I'm advised that there isn't anyone that we would have on our books. However, this is future focused. The Samsonine case was huge. It was distressing, and it was difficult for people in New Zealand to fathom that there was, at the point in time, nothing that we could do. Now, the previous government, to their credit, worked on this. It was very difficult and very tough in the case of a protected person. This is something that we can do, and I think we both agree that we should do, but it is future focused. We don't want this sort of a case to happen again where we sit there and go, well, there's nothing we can do. There has to be something, and this is something that we can do. But I can confirm with the member at this point, we're not aware of anybody. In terms of, and this is the second part that was mixed in slightly, and this is around the numbers of the people who are being discharged without conviction on the grounds that they may be deported. Look, we don't have exact numbers, but what is being reported to us, especially down south and in Queenstown and in the southern area of New Zealand, that it is happening more and more, that the case numbers are huge. And so this is why it is something that's being brought forward, because it is being circumnavigated. I just want to draw the members' attention to the definition of a security threat defined in Section 4 of the Act: terrorism, espionage, foreign interference. So it's very clearly defined in the Act.
Madam Chair. Honourable Phil Twyford.
Thank you. I do note that colleagues on the government benches are getting a bit antsy and taking closure motions, and I wanted...
Don't stress about it, Mr Twyford, I'll deal with that.
I just wanted to say, Madam Chair, that there are 9 discrete and substantive parts to this bill. And so far we've covered off the cancellation of residence class visas, we've covered off the new flexible powers of the Minister to benefit classes of persons, and we've dealt with the definition of mass arrivals. But can I just draw the Chair's attention to the other substantive parts that we haven't got to yet? We're currently talking about deportation and criminal offending, subpart 5. We haven't yet got to subpart 7 on out-of-hours warrants. We haven't yet dealt with charging of premiums, clause 47. We haven't yet dealt with very important subpart 8 on the warrants of commitment for asylum seekers, nor clause 41 on electronic monitoring.
This is your chance.
Yeah, and I'm just wanting to say to the Chair, who's only recently joined the session, these are very...
You've been watching since 9 a.m.
These are very substantive parts, and if I may say, there's been very little repetition, and we're having, I think, some pretty good dialogue. So I just wanted to say that. In relation to subpart 5 on amendments relating to deportation, I do think this is an important issue, and I wanted to ask the Minister, really in response to concerns that were raised by a number of submitters at committee, including the Law Society of New Zealand, concerns that the change undermines legal certainty and fairness, it erodes judicial oversight and due process protections. And I wanted to ask the Minister whether she'd considered whether this change would undermine the current potential advantage from an early guilty plea, that it risks incentivising more defended trials with flow-on effects on the justice system. The RIS notes that there is no data to support this change, and I wonder whether or not the Minister can, subsequent to the RIS, can offer us any data that backs this, supports this change. The RIS also frames the amendment as enhancing public confidence in the immigration system, and I wondered whether or not, again, whether there's any evidence to support that suggestion. The amendment would effectively nullify the deliberately conferred discretion vested in sentencing judges under Section 106 and 107 of the Sentencing Act, and which allows judges to consider the broader context, mitigating factors, and the personal consequences of a conviction. In light of all that, did the Minister seek advice from the Minister of Justice on this matter?
Madam Chair.
Honourable Erica Stanford.
There is still the discretion of the judge to discharge without conviction if he so wishes, but essentially the process that is being eroded is the process that already exists under Immigration New Zealand, the established process where delegated decision makers and the IPT have absolute full information about a case of a person who is liable for deportation. That is not the same when you have that situation with a judge, and it is circumnavigating another process at Immigration New Zealand where all of the relevant information around someone's deportation liability is considered. It's a long-held, established process that sits under the delegation of the immigration process, and it is being circumnavigated in far greater numbers than it ever has been without that full information, and the amendments that have been put forward on this will not be accepted.
Lawrence Sunan.
Madam Chair. Thank you, Minister, for her response previously. I want to move on to a new section, and I'm looking at Section 32, new Section 317AA. And I'm specifically looking at 317AA subsection 4, which is around threat or risk to public order. And I want to refer the Minister to my amendments at 840.31. Yep, which is to delete the section. So for the definition of threat or risk to public order, delete the part that says failing to comply with this act. Now, the reason I'm bringing this amendment to the Minister's attention is that I think neither the UNHCR's guidelines on the applicable criteria and standards relating to the detention of asylum seekers and the alternatives to detention or Victoria Casey's report on restriction of movement of asylum seekers identify failing to comply with the act as a factor which justifies detention, because there's a specific section on that. And both publications state that a short-term detention may be justified where there are threats to national security or public safety, or there are genuine real risk of absconding. So absconding, I agree, is an important part, but the failing to comply with the act isn't. So that's my amendment to the Minister if she would consider removing that particular part. The next part I want to talk about is actually in her amendment paper, so amendment paper 445, which is just being tabled yesterday. And part of that is to introduce new clause 40A and new clause 40B. And these two amendments are my amendments to the Minister's tabled amendments. My tabled amendments, the Minister's amendments are tabled at 840.33 and 840.34. Now, the reason I tabled these two is mainly just to note that there is I guess potentially a gap or oversight, unless the Minister is able to clarify, that when you're looking at 324B3, which is where you're making an application for release on condition for both non-claimant and claimant, what's missing there is consultation or input from the person through the application process, because the application, according to 324B subsection 2 and 324C subsection 2, is an immigration officer may apply. But so my two amendments basically addressing the fact that there's nothing that actually says the person themselves should be involved. So my amendment is just to say that to insert a new subclause, which is 3BB, to the minister's 3BA, which must include input from the person during the application process, such as why they believe they should be released on condition, or whether, for example, they believe certain conditions, such as electronic monitoring, which the previous speaker has spoken about, should not apply to their release. And this is a suggestion by the Law Society as well, so it just ensures that natural justice principles are upheld. And I think that is my three amendments that I want to engage with the Minister on at this stage. Thank you.
Madam Chair. Honourable Erica.
Two of those, I'm just waiting on the third one. But in terms of 840.34, the person will have legal representation, so they'll be able to present their views, the views of the person to the judge, so there's no reason for that amendment. You asked in your amendment, this is around Amendment 840.31, around why we need the part around, you want to remove the bit about failing to comply with the Act. For an example, failing to comply with the Act might be failing to comply with the terms of the RRRA, the residence and reporting requirements. And so that is very important, and that is one of the things that would be failing to comply with the Act, so which is why we won't be accepting that amendment either. And I'm just waiting on 33.
Honourable Phil Twyford.
Chair, I want to speak to subpart 7, the provisions that require immigration officers to obtain a judicial warrant prior to conducting out-of-hours residential compliance visits, otherwise known as dawn raids. The purpose of these provisions are to ensure that immigration compliance powers are exercised, when they're exercised outside of normal hours, are reasonable, proportionate, and in the public interest. And Labor strongly supports these changes. They arose out of the Heron review that our government initiated in response to the revelation that around the same time as our government made the dawn raids the historic apology, in fact, these visits were still going on. So it signals, as I said earlier, a departure from more punitive models of immigration control, and we appreciate that. I wanted to ask some questions of the Minister about whether or not specific provisions were considered to ensure that out-of-hours visits are a measure of last resort. The bill doesn't do that, and so I wonder what consideration has been given to ensuring that the way that these powers are implemented through procedures and policies and operations, it will ensure that that is in fact the practice. And I also wanted to refer to some tabled amendments but from Venushi Walters, my colleague, who has moved the following proposed amendment in clause 43 to add the following words in new section 324J3D, if given prior notice, unless there is a compelling reason not to do so. So that would...
Is there a number on the top of that?
104600. So that wording, I believe, would have the effect of ensuring the obligation is on, putting it in primary legislation to put the obligation in a much clearer and starker way that this is to be only carried out when all other avenues have been exhausted. Also, Venushi Walters tabled amendment 104601 and clause 26 to include a new section that reads, include an assessment of whether the proposed entry and search is compliant with international and domestic standards. And third, another amendment by Venushi Walters to clause 26. The amendment is time-stamped 104602, this would insert a new clause that would add disabled persons and pregnant persons to 293B3 3 and 4. Yep. So consider the potential impact of the proposed entry and search on anyone else who may be present in the dwelling or marae, including children, elderly persons, disabled persons, pregnant persons. So this is really about ensuring that the way that these powers are exercised would be consistent with our human rights obligations. And I hope that everybody in this House is highly sensitive to the history of the Dawn Raids and the importance of these powers being exercised in a way that is sensitive to the legacy of trauma that was from the aftermath of the Dawn Raids. Yeah, I'll leave that there. Look forward to the Minister's response.
Chair, sorry.
Honourable Erica Stanford.
Okay, going through those one by one, the first thing the member was asking about was the process and the safeguards in doing an out-of-hours compliance visit. As the member knows in this bill that the warrant has to be signed off by a judge. The judge needs to make sure that the actions are proportionate, that all other avenues or possibilities have been exhausted, and they do need to take into effect whether or not there are vulnerable people or children or situations in the household. So there are plenty of protections in the issuing of that warrant. Going through the amendments one by one, date time stamped 104600. From Venushi Walters. The intent of this amendment has already been met through the government's amendment paper requiring reasonable notice be given in writing. 104601, the amendment's not necessary as the domestic standards expressed in NZ BORA reflect international standards. And 104602, and this is around the disabled or vulnerable persons. These are included within the wording other vulnerable persons and do not need to be listed separately.
I'm tempted. As long as we are moving along, I'll call Ricardo Menendez-March.
Thank you, Madam Chair. I wanted to speak to my amendment 232007. This is in relationship to clause 42, in relationship to release on conditions. I know we've started talking a little bit about the provisions on electronic monitoring, and I wanted to seek clarification and then potentially support for my amendment because the way that I see the legislation being written in clause 42 in relationship to releasing conditions and basically a condition requiring the person to submit to electronic monitoring. I wonder whether, for the avoidance of doubt, whether she would want to make sure that the language specifies that it is an adult. The intent of this is to not have children being subjected to electronic monitoring. And so I did want to just ask whether she thinks that the language in clause 42 was adequate to just capture it as person, or whether it is her intention to subject underage people to electronic monitoring per the provisions in that clause. Clarification around that would be particularly useful, and so if she's able to both clarify that she does not intend to subject children to electronic monitoring, and if so, just for the avoidance of doubt, change the language if an adult as opposed to the person would be really, really useful. And I think this is particularly important because, we've seen that there are other provisions and other clauses that enable immigration officers to, for example, check the equipment, and, therefore there will be those interactions between immigration officials and the people subjected to electronic monitoring. I cannot see a particular benefit of or it would be good to understand if the Minister thinks there is, if any, a benefit of having an underage person being subjected to electronic monitoring. And if so, what are those? So again, seeking support for my amendment 232007 and clarification of underage people subjected to electronic monitoring.
Honourable Phil Twyford.
Thank you, Madam Chair. I wanted to speak to subpart 8, which to my mind is one of the most important parts of the bill, because it implements the, I think, you know, more or less the sort of final stages of the implementation of Victoria Casey's KC, as the Minister has been saying, the long list of recommendations that she made. I have a particular identification and strong attachment to this work. I was the Associate Minister when the report was done by Amnesty and the Asylum Support Seekers Trust, and with the support of Chris Farfoy, the Minister at the time, asked Immigration New Zealand to commission Victoria Casey. And I will note for the record that discussions with officials, Immigration New Zealand stoutly defended their track record and said there was nothing to see here, and that Immigration New Zealand's practice in this area was entirely consistent with New Zealand's international obligations. Victoria Casey found the opposite to be true, and that was an interesting moment.
And your question is?
The question is really that Victoria Casey delivered a pretty solid reform agenda, and I think there is good cross-party support for all of this implementation. But the Minister hasn't, with this bill, hasn't implemented all of her recommendations. So in relation to clause 27, irregular arrival is excluded as the sole basis for detention, but the bill doesn't expressly rule out things like administrative convenience or immigration compliance objectives. Why not? Victoria Casey also recommended, in line with UNHCR guidelines, that detention be reviewed within 48 hours and that maximum time limits be established. The bill retains the 4-day initial detention period before judicial oversight. Why is that? Third, why doesn't the bill prohibit the detention of asylum seekers in corrections facilities? This was one of the strongest recommendations by Victoria Casey, and the Amnesty International investigation showed how traumatic and dangerous it was for asylum seekers to be locked up in the Mount Eden remand facility. There were many examples of trauma and violence and abuse that asylum seekers were subjected to. Given how the government set up MIQ facilities during COVID, which could be guarded by security guards in a way that was secure, surely there is no need to retain, as this bill does, prisons as a detention facility of last resort for asylum seekers. Further, UNHCR told the committee that child refugees should never be detained for immigration-related purposes, and that families with children should never be separated from their families in detention. And I'll ask the Minister, why did she not support that advice? So in light of all that, Madam Chair, I wanted to speak to my tabled amendment to clause 27, which makes a number of proposals. It says, it proposes to insert in section 310 a new F. Any use of the powers of arrest and detention may only be exercised as a last resort, acknowledging that liberty is the default position.
What number? Sorry, Phil.
I'm sorry, I don't have the timestamp on that particular one. Next, a new clause G, the powers of arrest and detention may not be used for purposes not expressly permitted by the Act. Further, new H, any use of the powers of arrest and detention must receive judicial review within 24 to 48 hours of the initial detention. That would bring us in line, I believe, with UNHCR guidelines. New subclause I, any continuous detention must be reviewed independently at intervals of no longer than 7 days, with the burden of proof on the Crown to justify both initial and continued detention. New clause J, no detention is permitted for longer than 28 days, during which time
The Honourable Phil
detained... thank you, Madam Chair. During which time detained refugees and asylum seekers must be guaranteed the right to information in a language they understand, prompt and confidential access to a lawyer, and to bring judicial proceedings challenging the lawfulness of their detention. New subclause K, no detention is permitted of a person or persons under the age of 18, nor of families with children, nor any detention that separates parents from children. And finally, new subclause L, prisons and correctional facilities may not be used for detention purposes. Now, I believe the effect of this amendment would be to ensure that this bill fully reflects the recommendations made by Victoria KCQC, and I urge the Minister to give it serious consideration.
Lawrence Sunan.
I would also like to speak on a new part of the bill under subpart 8 that we haven't covered yet, and as well as one of my amendments, and that is clause 40, new 324F, subclause 3D, which is where it states, and this is this is on page 31, line 11 of the bill, where it says a condition that the released person take a specific action for the purpose of facilitating the person's deportation or departure from New Zealand. The issue that has been raised around this specific clause is, while it is comparable or has parallels to the previous subclause C, the released person in this case, because it's about facilitating the person's deportation, needs to specify that that released person is a non-claimant, because the concern would be that it would not be appropriate where the refugee or a refugee claimant's claim that has not yet been finally determined, or someone who is, for example, going through and the deportation or departure risk breaches Aotearoa New Zealand's non-refoulement obligations under the Refugee Convention. So this particular amendment is just to ensure that we are not going to capture those instances where claimants are also going to be factored into this particular part. So that's a very small and discrete amendment. Sorry, the amendment is 84032.
Madam Chair.
Lydia Sassini.
Thanks, Madam Chair. I really appreciate the opportunity. Madam Chair, I just wanted to seek clarification from the Minister, who has already covered this. But in her reply, I would just like to revisit and just quickly go back to section 25, which is the section 286 in the Principal Act, Powers of Entry and Search. And Honourable Phil Twyford asked some questions to do with the dawn raids. And what I wanted to get assurance from the Minister, who replied to Honourable Phil Twyford's question, was just around the warrant. And the Minister's reply to the out of hours warrant, that the section 293B subsection 2, that the application is made to the district court judge, and that it is to take into account when the judge is doing the warrant and approving it, proportionate and vulnerable protections. Minister, what I wanted to ask you was that A, do the officials, because I appreciate that it's operational and that you would get reporting from time to time as would expect, do you have officials who give the breakdown of those out of hours warrants? And also, is there any other information that's provided to you with respect to the fear and the trauma that it leaves with particularly New Zealand citizen families who I don't support that they're harbouring sometimes, but they're really complex situations. The reason why I ask for clarity around that, Minister, whether you get some of that other information, is because in electorate offices like mine, it is the family members who are legal citizens who come to the office seeking any other way to help their people or family members who have been arrested, removed and out of hours, because from time to time these family members are coming to MPs of different parties and expressing their strong views around that. So I just wanted to request and ask, is any of that official information passed on to you, Minister? Thank you.
Madam Chair.
The Honourable Erica Stanford.
Madam Chair, this is a section we've been over, but to repeat myself, any out-of-hours activity needs to be signed off with a judicial warrant, and the judge will have to take into account many factors. Is it the last resort? Has everything else been discounted? Are there vulnerable people in the house? Are there any other things that would mean that this was not the appropriate action to take? And those safeguards are baked in. I just want to go through some of Phil Twyford's questions. The question was proposing to include provisions guaranteeing the right to information in a language they understand and legal representation. This is already provided for in Bora. There was a question around proposed amendment to ban the detention of children. It's, again, very unlikely this would happen. A judge is unlikely to consider this as proportionate, reasonable, or the least restrictive measurement necessary. So those things are already built in. And more broadly on the Amendment 62001, these changes would make substantive changes to the detention regime and require significant reworking of Part 9 of the Act, and operational changes like purpose-built detention centres would need to be considered, given the members' requirements that prisons and correctional facilities may not be used for detention purposes. So this is not something that we will be considering.
Ricardo Menendez-March.
Madam Chair, I wanted to speak to my Amendment 23-2003 in relationship to Clause 26. Now, apologies, sorry, it's 23-2004, my bad. They were just next to each other. So this is in relationship to also Clause 26 though, but the question I had for the Minister was, we've talked about the Heron KC report throughout the questions, and it's been mentioned in the answers, but one of the recommendations there, and one of the options that was given, was to limit out-of-hours immigration rates to situations involving public safety or matters of national security. And so can I ask to the Minister, why not just follow that recommendation, and rather than leaving it at the discretion of basically a judge, just make it extremely clear that we're narrowing it down to two specific criteria as to then prevent loading the judiciary with additional work to be able to determine as to when out-of-hour visits are appropriate or otherwise, and to just then create two very specific situations noted by the Heron KC report. And I also note this because what we've noted throughout the debate in terms of the role of the judiciary when it comes to decision-making of the different provisions of the bill is that there seems to be a bit of a not contradiction, but I guess a different application of how the Minister chooses to trust the judgment of a judge, for example, when it comes to liability of deportations, where that's being passed on to Immigration New Zealand, but it seems like she is quite happy to then leave that and to a judge when it comes to out-of-hour visits. And I think in some ways by being able to restrict the two criteria to just public safety and matters of national security, I think we could just better strengthen the rights of people who could be subjected to out-of-hour visits, and genuinely honour these recommendations and the apology that happened in relationship to the Dawn raids. One of the other areas that I wanted to go back to is to more this, in one of her contributions, and I did appreciate her engagement around the definition of security. During the debate, I went back to the Principal Act and noted that the way that security is defined is not just to provisions of terrorism that she noted. It also includes provisions around affecting our reputation, for example, which is actually quite broad. So I think it's a little bit of red herring maybe, or just a very extreme example to just point out to the terrorism components of the definition of security, but not recognize that actually we have quite a broad definition when it comes to reputation. How does a minister see the definition of reputation impacting the ability for the minister to effectively make someone liable for deportation should to strip someone's residency and put them on a temporary visa, should they be deemed as a risk to our reputation? Because I know she used the example of terrorism, but I think we've got to be intellectually honest with ourselves, and I'm not accusing the minister of otherwise, but it's just let's be clear about what actually the definition of security is. So the third questions were simply just, would she support my amendment to narrow the scope that out-of-hour visits can happen? And can she please clarify how she would apply the provisions in the Principal Act on security when it comes to reputation for the purposes of stripping someone's residency away should they be deemed a threat to our security, not just the most extreme examples when it comes to terrorism. And I would appreciate the engagement and particularly her commitment to the options given in the Harold KC report.
Honourable Minister.
Dealing with those two in reverse order, the definition of national security is not in scope of this bill. It is a previously determined definition, and we won't be entertaining any changes as it's not in scope. In terms of the Amendment 23-2003, in the name of the member, essentially this is deleting. Okay, well let's deal with them both since we're here, because 23-2003 essentially is deleting clause 26, which is just removing the ability to do an out-of-hours compliance visit. Of course, we will not be supporting this. It is really important that there is an option of absolute last resort that has plenty of safeguards and guardrails around it in terms of the fact that we need to go to the judge to get a judicial warrant in order to undertake this activity. And as I've already mentioned on 2 or 3 occasions now, that all those safeguards exist there. But the point is that there are always people who use this as a loophole because they know that if they are in a certain place at a certain time, compliance activity cannot be undertaken. And it makes it very, very difficult for Immigration New Zealand to make sure that people are abiding by the terms of their visa, and if it is time for them to leave the country, that we are able to undertake that activity. But as already mentioned, we have looked at the recommendations of the Casey report and made sure that we've put all those safeguards in place. And just also, while I'm here, it reminded me of a question that Phil Twyford asked earlier about the recommendations of the Casey review. I think there's only one more that we need to put in place, and that's coming in the next bill that we'll be introducing. And I'll get to 2304 in a second.
Carl Bates.
I move the debate on this question now close.
I've been watching for the last hour, and I was here for the hour before this, and I've just observed that the spokesperson for Labour has a couple more burning questions, but I'm indicating now that we've, and the Minister's been very engaging. So, Honourable Phil Twyford, I'll take a couple of questions from you. Thank you.
Chair, we haven't yet dealt with electronic monitoring clause 41 or Clause 47, charging of premiums, 2 very important parts of the bill. But I wanted to speak to my amendments around Clause 32. Now, this is important. We've dealt with a similar issue in principle but not in relation to Clause 32. And it's really about the precise wording that would justify, in this instance, detention of an asylum seeker. So Clause 32 inserts new section 317AA, which sets out the options available to a district court judge when considering an application for a warrant of commitment. And the Law Society at Select Committee expressed concerns about the phrase threat or risk to public order in new section 317AA 4B. So these are the justifications for, this is the core of the justification for a warrant of commitment. Now, neither the UNHCR guidelines nor the Casey report identify failing to comply with the Immigration Act as a factor which justifies detention. Both of them say, both the guidelines and the Casey report say that short-term detention may be justified where there are threats to national security, like or public safety, or genuine and real risks of absconding. And I agree with the Law Society on this case that detention outside of those limited circumstances is not justified. And so my amendment is to Clause 32 would, in new section 317AA, subclause 2B, after the word risk, insert of absconding. Because at the moment, risk just on its own is extremely broad. Risk of what? And so I think it would be better if we insert the words of absconding after the word risk. And also in the second tabled amendment to subclause 2A. So 2A and 2B of new section 317AA, let's tighten up risk by inserting the words of absconding.
Madam Speaker.
Honourable Minister.
Yeah, sorry. We've dealt with this one before. This is not the first time this has come up. The deletion of this, that they have to comply with the Act, and I already made this point that not complying with the Act might be something like not abiding by your RRA, residence and reporting requirements, something like that you were not where you were supposed to be and you weren't reporting in, for example, or another something that might be against the Act will be failure to turn up to an interview. So there are a number of things that are really important around retaining that part that Mr. Twyford wants to get rid of in that amendment. But I've dealt with that before in someone else's, so it's not the first time that's come up.
Carlos Chong. The question is that debate on this question now closed. All those in favour say aye. To the contrary, no. The ayes have it. The ayes have it. No, too late. I've called the ayes have it. So the question is that Dr. Lawrence Yunan's tabled amendment to AP number 445, amending new clause 40A, be agreed to. All those in favour say aye. To the contrary, no. No. The noes have it. Party vote's been called, please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te kau mā whā ngā pōti whakaai.
Act New Zealand.
Eleven opposed.
New Zealand First.
8 votes opposed.
Party Māori.
E whā ngā pōti whakaai.
Takuta Ferris.
Kotahi te pōti whakaai.
Maria Mano Kapakinga.
Kotahi te pōti whakaai.
The ayes are 54, the noes are 68. 54. Can I just check with the Green Party what your vote number was?
Tacoma Far. 14.
Yeah, 14.
Yeah, okay, thank you. So the ayes are 54, the noes are 68. The question is not agreed. Question is that Dr. Lawrence Yunan's tabled amendment to AP number 445, amending new clause 40B, be agreed to. All those in favour say aye. To the contrary, no. No. The noes have it. Party vote is called, please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Tacoma Far ngā poti whakaai.
Act New Zealand.
11 opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
E whā ngā poti whakaai.
Tākuta Ferris.
Kotahi te poti whakaai.
Maria Meno Kapakingi.
Kotahi te poti whakaai.
The ayes are 54, the noes are 68. The question is not agreed.
We need to pause here because we've got another amendment. So I'm just going to tell you what we're voting on that one. We can't because it's an amendment to the amendment. So
Just a moment. That one. Thank you. So I'll give you the old one. There you go. The question is that Ingrid Leary's tabled amendment to AP number 445, deleting new clauses 40A and 40B, be agreed to. All those in favour say aye. To the contrary, no. No. The noes have it. Party votes called, please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Tacoma Far ngā poti whakaai.
Act New Zealand.
11 opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
E whā ngā poti whakaai.
Tākuta Ferris.
Kotahi te poti whakaai.
Maria Meno Kapakingi.
Kotahi te poti whakaai.
The ayes are 54, the noes are 68. The question's not agreed. The question is that the Minister's amendments to Part 1 set out on AP number 445 be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The ayes have it. Party votes been called for, please, Clerk.
New Zealand National.
49 votes in favour.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Tacoma Far ngā poti whakahē.
Just going to check that vote again.
So,
Yes, I think it's no. I've got the translations in.
can we just check that vote again, please?
Tacoma Far ngā poti whakahē. 14 opposed.
Act New Zealand.
In favour.
New Zealand First.
8 votes in favour.
Te Pāti Māori.
E whā ngā poti whakahē.
Tākuta Ferris.
Kotahi te poti whakahē.
Maria Meno Kapakingi.
Kotahi te poti whakahē.
The ayes are 102, the noes are 20. The question is agreed. The question is that Dr. Lawrence Yunan's tabled amendment to clause 4.1, amending the definition of first available craft to insert or after a representative of the person being notified, be agreed to. All those in favour say aye. To the contrary, no. No. Noes have it. Party votes called, please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te kaumawha ngā poti whakaai.
Act New Zealand.
11 opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
E whā ngā poti whakaai.
Tākuta Ferris.
Kotahi ngā te poti whakaai.
Maria Meno Kapakingi.
Kotahi te poti whakaai.
The ayes are 54, the noes are 68. The question's not agreed. The question is that Dr Lawrence Yunan's tabled amendment to clause 4.1, amending the definition of first available craft to insert unless in exceptional circumstances be agreed to. All those in favour say aye. Aye. Contrary, no. No. Noes have it. Party vote call, please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te kaumawha ngā poti whakaai.
Act New Zealand.
11 opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
E whā ngā poti whakaai.
Tākuta Ferris.
Kotahi te poti whakaai.
Maria Meno Kapakingi.
Kotahi te poti whakaai.
The ayes are 54, the noes are 68. The question's not agreed. The question is that Dr Lawrence Yunan's tabled amendment to clause 4.1, amending the definition of first available craft to insert and section 166 be agreed to. All those in favour say aye. Aye. Contrary, no. No. Noes have it. Party vote called for, please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te kaumawha ngā poti whakaai.
Act New Zealand.
11 opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
E whā ngā poti whakaai.
Tākuta Ferris.
Kotahi te poti whakaai.
Maria Meno Kapakingi.
Kotahi te poti whakaai.
The ayes are 54, the noes are 68. The question's not agreed. Question is that Ricardo Menendez March's tabled amendment to clause 4.1, amending the definition of first available craft be agreed to. All those in favour say aye. Aye. To the contrary, no. No. Noes have it. Party vote called, please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
14 votes in favour.
Act New Zealand. New Zealand First.
Votes opposed.
Te Pāti Māori.
In favour.
Tākuta Ferris.
1 vote in favour.
Maria Meno Kapakingi.
1 vote in favour.
The ayes are 54, the noes are 68. The question is not agreed. Question is that Dr Lawrence Yunan's tabled amendment to clause 4.1, amending the definition of irregular entry into New Zealand to insert willingly be agreed to. All those in favour say aye. Aye. Contrary, no. No. Noes have it. Party vote called, please.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
15 votes in favour. Sorry, apologies, 14 votes in favour. Yeah.
Act New Zealand.
11 opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
4 votes in favour.
Tākuta Ferris.
1 vote in favour.
Maria Meno Kapakingi.
1 vote in favour.
The ayes are 54, the noes are 68. The question's not agreed. Honourable Phil Twyford's tabled amendment to clause 4.1 inserting new paragraph C is out of order as not being in the correct form of legislation. Question is that Dr Lawrence Yunan's tabled amendment to delete clause 5.2 be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. Party vote called, please.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
14 votes in favour.
Act New Zealand.
11 opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
4 votes in favour.
Taku Te Wharis.
1 vote in favour.
Maria Mino Kapakingi.
1 vote in favour.
The ayes are 54, the noes are 68. The question's not agreed. Question is that Dr Lawrence Yunan's tabled amendment to clause 7, new section 50, 4D, inserting new paragraph AA be agreed to. All those in favour say aye. Aye. Contrary no. No. Noes have it. The ayes have it. Party vote called, please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
14 votes in favour.
Act New Zealand.
11 opposed.
New Zealand First.
Waru ngā pauti whakahei.
Te Pāti Māori.
4 votes in favour.
Taku Te Wharis.
1 vote in favour.
Maria Mino Kapakingi.
1 vote in favour.
Just while the clerk's counting the votes, could I ask the member, it's easier if you stand for the, if you're doing 3 consecutive votes, I'm happy for you to stand for the whole time until the 3 votes have done, as others have been doing. Thank you. No, it's not an option, it's a request. Thank you. The ayes are 54, the noes are 68. The question is not agreed. The question is that Venushi Walters' tabled amendment to clause 7, new section 50, 4DB, inserting new subparagraph 3 be agreed to. All those in favour say aye. Contrary no. No. The noes have it. Party vote called, please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
14 votes in favour.
Act New Zealand.
11 opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
4 votes in favour.
Taku Te Wharis.
1 vote in favour.
Maria Mino Kapakingi.
1 vote in favour.
Thank you. It's just quicker.
Okay.
It just wastes a lot of time getting up and down. Thank you. The ayes are 50. No, we're voting. I don't want any, I'm sitting in the chair. I don't want any other commentary. Thank you. The ayes are 54, the noes are 68. The question is not agreed. Question is that Venushi Walters' tabled amendment to clause 7, new section 50, 4D-C be agreed to. All those in favour say aye. To the contrary, no. The noes have it. Party vote has been called, please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
14 votes in favour.
Act New Zealand.
11 opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
4 votes in favour.
Taku Te Wharis.
1 vote in favour.
Maria Mino Kapakingi.
1 vote in favour.
The ayes are 54, the noes are 68. The question's not agreed. The question is that Dr Lawrence Yunan's tabled amendment to clause 7, new section 50, 4EB be agreed to. All those in favour say aye. Aye. Contrary, no. No. Noes have it. Party votes being called, please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
14 votes in favour.
Act New Zealand.
11 opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
4 votes in favour.
Taku Te Wharis.
1 vote in favour.
Maria Mino Kapakingi.
1 vote in favour.
The ayes are 54, the noes are 68. The question is not agreed. Question is that Dr Lawrence Yunan's tabled amendment to clause 7, new section 50, 4E-C be agreed to. All those in favour say aye. Aye. To contrary, no. No. Noes have it. Party votes being called, please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
14 votes in favour.
Act New Zealand.
11 opposed.
New Zealand first.
8 votes opposed.
Te Pāti Māori.
4 votes in favour.
Taku Te Wheres.
1 vote in favour.
Maria Mino Kapakingi.
1 vote in favour.
The ayes are 54, the noes are 68. The question is not agreed. The question is that Dr Lawrence Yunan's tabled amendment to Clause 7, Section 50, inserting new subsection 4F relating to ministerial discretion be agreed to. All those in favour say aye. Contrary, no. Noes have it. Party vote called, please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
14 votes in favour.
Act New Zealand.
11 opposed.
New Zealand first.
Opposed.
Te Pāti Māori.
4 votes in favour.
Taku Te Wheres.
1 vote in favour.
Maria Mino Kapakingi.
1 vote in favour.
The ayes are 54, the noes are 68. The question is not agreed. The question is that Dr Lawrence Yunan's tabled amendment to Clause 7, Section 50, inserting new subsection 4F to review the effectiveness of a special direction be agreed to. All those in favour say aye. Aye. Contrary, no. No. Noes have it. The ayes have it. Party votes being called, please, Clerk.
New Zealand National.
9 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
14 votes in favour.
Act New Zealand.
11 opposed.
New Zealand first.
8 votes opposed.
Te Pāti Māori.
4 votes in favour.
Taku Te Wheres.
1 vote in favour.
Maria Mino Kapakingi.
1 vote in favour.
The ayes, excuse me, the ayes are 54, the noes are 68. The question is not agreed. The question is that Dr Lawrence Yunan's tabled amendment to Clause 8, new Section 52(4)A be agreed to. All those in favour say aye. Aye. Contrary, no. No. Noes have it. The ayes have it. Party votes being called, please.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
14 votes in favour.
Act New Zealand.
11 opposed.
New Zealand first.
8 votes opposed.
Te Pāti Māori.
4 votes in favour.
Taku Te Wheres.
1 vote in favour.
Maria Mino Kapakingi.
1 vote in favour.
The ayes are 54, the noes are 68. The question's not agreed. Question is that Dr Lawrence Yunan's tabled amendment to Clause 8, new Section 52(4)D to insert new paragraph AA be agreed to. All those in favour say aye. Aye. Contrary, no. No. Noes have it. Party vote, please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
14 votes in favour.
Act New Zealand.
11 opposed.
New Zealand first.
8 opposed.
Te Pāti Māori.
4 votes in favour.
Taku Te Wheres.
1 vote in favour.
Maria Mino Kapakingi.
1 vote in favour.
The ayes are 54, the noes are 68. The question's not agreed. The question is that Dr Lawrence Yunan's tabled amendment to Clause 8, new Section 52(4)E)(B) be agreed to. All those in favour say aye. Aye. Contrary, no. No. Noes have it. Party vote called, please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
14 votes in favour.
Act New Zealand.
11 opposed.
New Zealand first.
8 opposed.
Te Pāti Māori.
4 votes in favour.
Taku Te Wheres.
1 vote in favour.
Maria Mino Kapakingi.
1 vote in favour.
The ayes are 54, the noes are 68. The question's not agreed. The question is that Dr Lawrence Yunan's tabled amendment to Clause 8, new Section 52(4)E)(C be agreed to. All those in favour say aye. Aye. Contrary, no. Noes have it. Party vote called, please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 in favour.
Green Party of Aotearoa, New Zealand.
14 votes in favour.
Act New Zealand.
11 opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
4 votes in favour.
Takuta Ferris.
1 vote in favour.
Mariamino Kapakingi.
1 vote in favour.
The ayes are 54, the noes are 68. The question's not agreed. Question is that Dr Lawrence Yunan's tabled amendment to Clause 8, new Section 52, inserting new subsection 4F relating to ministerial discretion be agreed to. All those in favour say aye. Aye. Contrary, no. No. Noes have it. The ayes have it. Party vote's been called, please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
15 votes in favour. 14 votes in favour.
Act New Zealand.
11 opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
4 votes in favour.
Takuta Ferris.
1 vote in favour.
Mariamino Kapakingi.
1 vote in favour.
The ayes are 54, the noes are 68. The question's not agreed. Question is that Dr Lawrence Yunan's tabled amendment to Clause 8, new subsection 52, inserting new subsection 4F to review the effectiveness of a special direction be agreed to. All those in favour say aye. Aye. Contrary, no. No. Noes have it. The ayes have it. Party vote called, please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
14 votes in favour.
Act New Zealand.
11 opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
4 votes in favour.
Takuta Ferris.
1 vote in favour.
Mariamino Kapakingi.
1 vote in favour.
The ayes are 54, the noes are 68. The question's not agreed. Question is that Dr Lawrence Yunan's tabled amendment to Clause 9, new Section 53 4A be agreed to. All those in favour say aye. Aye. Contrary, no. No. Noes have it. The ayes have it. Party vote called, please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
14 votes in favour.
Act New Zealand.
11 opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
4 votes in favour.
Takuta Ferris.
1 vote in favour.
Mariamino Kapakingi.
1 vote in favour.
The ayes are 54, the noes are 68. The question is not agreed. The question is that Vanushi Walters' tabled amendment to Clause 9, new Section 53 4B be agreed to. All those in favour say aye. Contrary, no. No. Noes have it. Party vote has been called, please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
14 votes in favour.
Act New Zealand.
11 opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
4 votes in favour.
Takuta Ferris.
1 vote in favour.
Mariamino Kapakingi.
1 vote in favour.
The ayes are 54, the noes are 68. The question's not agreed. The question is that Dr Lawrence Yunan's tabled amendment to Clause 9, new Section 53 4D, inserting new paragraph AA be agreed to. All those in favour say aye. Aye. Contrary, no. No. Noes have it. Party vote called, please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
14 votes in favour.
Act New Zealand.
11 opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
4 votes in favour.
Takuta Ferris.
1 vote in favour.
Maria Mino Kapakingi.
1 vote in favour.
The ayes are 54, the noes are 68. The question's not agreed. Question is that Dr Lawrence Yunan's tabled amendment to clause 9, new section 53 4E(b) be agreed to. All those in favour say aye. Aye. Contrary no. No. Noes have it. Party vote called, please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
14 votes in favour.
Act New Zealand.
11 opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
4 votes in favour.
Takuta Ferris.
1 vote in favour.
Maria Mino Kapakingi.
1 vote in favour.
The ayes are 54, the noes are 68. The question's not agreed. The question is that Dr Lawrence Yunan's tabled amendment to clause 9, new section 53 4E(c) be agreed to. All those in favour say aye. Aye. Contrary no. No. Noes have it. Party vote has been called, please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
14 votes in favour.
Act New Zealand.
11 opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
4 votes in favour.
Takuta Ferris.
1 vote in favour.
Maria Mino Kapakingi.
1 vote in favour.
The ayes are 54, the noes are 68. The question is not agreed. Question is that Dr Lawrence Yunan's tabled amendment to clause 9, new section 53, inserting new subsection 4F, relating to ministerial discretion be agreed to. All those in favour say aye. Aye. Contrary no. No. Noes have it. Party vote has been called, please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
14 votes in favour.
Act New Zealand.
11 opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
4 votes in favour.
Takuta Ferris.
1 vote in favour.
Maria Mino Kapakingi.
1 vote in favour.
The ayes are 54, the noes are 68. The question is not agreed. Question is that Dr Lawrence Yunan's tabled amendment to clause 9, new section 53, inserting new subsection 4F, to review the effectiveness of a special direction be agreed to. All those in favour say aye. Aye. Contrary no. No. Noes have it. Party vote's been called, please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
14 votes in favour.
Act New Zealand.
11 opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
4 votes in favour.
Takuta Ferris.
1 vote in favour.
Maria Mino Kapakingi.
1 vote in favour.
The ayes are 54, the noes are 68. The question is not agreed. The question is that Dr Lawrence Yunan's tabled amendment to clause 10, new section 57(6), inserting new paragraph AA be agreed to. All those in favour say aye. Aye. Contrary no. No. Noes have it. Party vote is called, please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
14 votes in favour.
Act New Zealand.
11 opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
4 votes in favour.
Takuta Ferris.
1 vote in favour.
Maria Mino Kapakingi.
1 vote in favour.
The ayes are 54, the noes are 68. The question is not agreed. Question is that Dr Lawrence Yunan's tabled amendment to clause 10, new section 57(7)(b) be agreed to. All those in favour say aye. Aye. Contrary no. No. Noes have it. Party votes called, please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
14 votes in favour.
Act New Zealand.
11 opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
4 votes in favour.
Takuta Ferris.
1 vote in favour.
Maria Mino Kapakingi.
1 vote in favour.
The ayes are 54, the noes are 68. The question is not agreed. The question is that Dr Lawrence Yunan's tabled amendment to clause 10, new section 57(7)(c) be agreed to. All those in favour say aye. Aye. Contrary, no. No. Noes have it. The ayes have it. Party vote called, please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
14 votes in favour.
Act New Zealand.
11 opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
4 votes in favour.
Takuta Ferris.
1 vote in favour.
Maria Mino Kapakingi.
1 vote in favour.
The ayes are 54, the noes are 68. The question's not agreed. The question is that Dr Lawrence Yunan's tabled amendment to clause 10, new section 57, inserting new subsection 8, relating to ministerial discretion be agreed to. All those in favour say aye. Aye. Contrary, no. No. Noes have it. Ayes have it. Party vote's been called, please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
4 votes in favour.
Green Party of Aotearoa, New Zealand.
15, just clarifying it's correct, 15 votes in favour. We're back to full vote. Yeah.
Act New Zealand.
11 opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
4 votes in favour.
Takuta Ferris.
1 vote in favour.
Maria Mino Kapakingi.
1 vote in favour.
The ayes are 55, the noes are 68. The question's not agreed. The question is that Dr Lawrence Yunan's tabled amendment to clause 10, new section 57, inserting new subsection 8, to review the effectiveness of a special direction be agreed to. All those in favour say aye. Aye. Contrary, no. No. Noes have it. The ayes have it. Party vote called, please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
14 votes in favour. Tied. 15 votes in favour. We're back at full strength.
Act New Zealand.
11 opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
4 votes in favour.
Takuta Ferris.
1 vote in favour.
Maria Mino Kapakingi.
1 vote in favour.
The ayes are 55, the noes are 68. The question's not agreed. The question is that Venushi Walters' tabled amendment to clause 11, new section 61B(3), inserting new paragraph E relating to the Genocide Convention be agreed to. All those in favour say aye. Aye. Contrary, no. No. The noes have it. The ayes have it. Party vote called, please, Clerk. Oh.
I think we might have just got out of order here for a moment.
Oh, just one moment.
Have you just read the same one twice?
This one I just read, Venushi Walters.
No, it's Johnson.
I've got 2 consecutive Venushi Walters ones here. I've just read.
Yeah. All right, that's fine. We just get finish up with that one there. Can you write up that motion? Okay. So the next one we're doing is the one about Genocide Convention.
Yes, this one. Do you want me to read it again?
Yeah.
Okay. I'm just going to read this one again just to clarify. The question is that Venucci-Walters tabled amendment to Clause 11, new Section 61B3, inserting new paragraph E, relating to the Genocide Convention, be agreed to. All those in favour say aye. Aye. Contrary, no. No. Noes have it. Party vote is called, please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
15 votes in favour.
Act New Zealand.
11 opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
4 votes in favour.
Takuta Ferris.
1 vote in favour.
Maria Mino Kapakingi.
1 vote in favour.
The ayes are 55, the noes are 68. The question's not agreed. The question is that Venucci-Walters tabled amendment to Clause 11, new Section 61B3, inserting new paragraph E, relating to human rights or humanitarian issues, be agreed to. All of those in favour say aye. Aye. Contrary, no. No. Noes have it. Party vote called, please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
15 votes in favour.
Act New Zealand.
11 opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
4 votes in favour.
Takuta Ferris.
1 vote in favour.
Maria Mino Kapakingi.
1 vote in favour.
The ayes are 55, the noes are 68. The question's not agreed. The question is that Ricardo Menendez March's tabled amendments deleting clause 12 to 14 be agreed to. All those in favour say aye. Aye. Contrary, no. No. Noes have it. Aye. Party vote called, please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes opposed.
Green Party of Aotearoa, New Zealand.
15 votes in favour.
Act New Zealand.
11 opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
4 votes in favour.
Takuta Ferris.
1 vote in favour.
Maria Mino Kapakingi.
1 vote in favour.
The ayes are 21, the noes are 102. The question is not agreed. Question is that Honourable Phil Twyford's tabled amendment to Clause 13, replacing Section 75A1, be agreed to. All those in favour say aye. Aye. Contrary, no. No. Noes have it. Party vote called, please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Oh, sorry,
15 votes in favour.
We actually have a minister in the chair, sorry.
Yeah. Green Party of Aotearoa, New Zealand.
Thank you. 15 votes in favour.
Act New Zealand.
11 opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
4 votes in favour.
Takuta Ferris.
1 vote in favour.
Maria Mino Kapakingi.
1 vote in favour.
The ayes are 55, the noes are 68. The question is not agreed. Question is that Ricardo Menendez March's tabled amendment deleting subpart 5 be agreed to. All those in favour say aye. Aye. Contrary, no. No. Noes have it. Party vote's been called, please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes opposed.
Green Party of Aotearoa, New Zealand.
15 votes in favour.
Act New Zealand.
11 opposed.
New Zealand First. New Zealand First.
8 votes opposed.
Te Pāti Māori.
4 votes in favour.
Takuta Ferris.
1 vote in favour.
Maria Mino Kapakingi.
1 vote in favour.
The ayes are 21, the noes are 102. The question is not agreed. The question is that Dr Lawrence Yunan's tabled amendment to clause 18, deleting subclauses 1AA and 1 be agreed to. All those in favour say aye. Aye. Contrary, no. No. Noes have it. Party votes being called. Please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
15 votes in favour.
Act New Zealand.
11 opposed.
New Zealand First.
8 opposed.
Party Māori.
4 votes in favour.
Taku Te Wheres.
1 vote in favour.
Maria Manu Kapitini.
1 vote in favour.
The ayes are 55, the noes are 68. The question is not agreed. Question is that Ricardo Menendez March's tabled amendment deleting clause 26 be agreed to. All those in favour say aye. Aye. Contrary, no. No. Noes have it. Party vote called, please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes opposed.
Green Party of Aotearoa, New Zealand.
15 votes in favour.
Act New Zealand.
11 opposed.
New Zealand First.
8 votes opposed.
Party Māori.
4 votes in favour.
Taku Te Wheres.
1 vote in favour.
Maria Manu Kapitini.
1 vote in favour.
The ayes are 21, the noes are 102. The question's not agreed. The question is that Ricardo Menendez March's tabled amendment to clause 26, amending paragraph E and inserting new paragraph F be agreed to. All those in favour say aye. Aye. Contrary, no. No. The noes have it. Party votes called, please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes opposed.
Green Party of Aotearoa, New Zealand.
15 votes in favour.
Act New Zealand.
11 opposed.
New Zealand First.
8 votes opposed.
Party Māori.
4 votes in favour.
Taku Te Wheres.
1 vote in favour.
Maria Manu Kapitini.
1 vote in favour.
The ayes are 21, the noes are 102. The question's not agreed. Question is that Venushi Walters' tabled amendment to clause 26, new section 293B3C be agreed to. All those in favour say aye. Aye. Contrary, no. No. Noes have it. Party vote has been called, please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
15 votes in favour.
Act New Zealand.
11 opposed.
New Zealand First.
8 votes opposed.
Te Party Māori.
4 votes in favour.
Taku Te Wheres.
1 vote in favour.
Maria Manu Kapitini.
1 vote in favour.
The ayes are 55, the noes are 68. The question is not agreed. The question is that Venushi Walters' tabled amendment to clause 26, inserting paragraph F into new section 293B3 be agreed to. All those in favour say aye. Aye. Contrary, no. No. Noes have it. Party vote called, please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
15 votes in favour.
Act New Zealand.
11 opposed.
New Zealand First.
8 votes opposed.
Te Party Māori.
4 votes in favour.
Taku Te Wheres.
1 vote in favour.
Maria Manu Kapitini.
1 vote in favour.
The ayes are 55, the noes are 68. The question is not agreed. The question is that Honourable Phil Twyford's tabled amendment to clause 27, inserting new subclauses 3 to 10 be agreed to. All those in favour say aye. Aye. Contrary, no. No. Noes have it. Party vote called, please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
15 votes in favour.
Act New Zealand.
11 opposed.
New Zealand First.
8 votes opposed.
Te Party Māori.
4 votes in favour.
Taku Te Wheres.
One vote in favour.
Maria Manu Kapakingi.
One vote in favour.
The ayes are 55, the noes are 68. The question's not agreed. The question is that Honourable Phil Twyford's tabled amendment to clause 32, new section 317 AA2 B1A be agreed to. All those in favour say aye. Aye. To the contrary, no. No. Noes have it. Party vote called, please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
15 votes in favour.
Act New Zealand.
11 opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
4 votes in favour.
Taku Te Wheres.
1 vote in favour.
Maria Manu Kapakingi.
1 vote in favour.
The ayes are 55, the noes are 68. The question is not agreed. The question is that Honourable Phil Twyford's tabled amendment to clause 32, new section 317 AA2 B1B be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. Party votes being called for, please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
15 votes in favour.
Act New Zealand.
11 opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
4 votes in favour.
Taku Te Wheres.
1 vote in favour.
Maria Manu Kapakingi.
1 vote in favour.
The ayes are 55, the noes are 68. The question is not agreed. The question is that Dr Lawrence Yunan's tabled amendment to clause 32, new section 317AA4, deleting paragraph B, in the definition of threat or risk to public order be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. Party votes being called, please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
15 votes in favour.
Act New Zealand.
11 opposed.
New Zealand First.
Votes opposed.
Te Pāti Māori.
4 votes in favour.
Taku Te Wheres.
1 vote in favour.
Maria Manu Kapakingi.
1 vote in favour.
The ayes are 55, the noes are 68. The question is not agreed. What's wrong with you up to?
Sorry, you're on page 7. 7, yeah, and so, yeah.
The question is that Dr Lawrence Yunan's tabled amendment to clause 40, new section 324F be agreed to. All those in favour say aye. Aye. To the contrary, no. No. Noes have it. Please conduct a party vote.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
15 votes in favour.
Act New Zealand.
11 opposed.
New Zealand First.
Votes opposed.
Te Pāti Māori.
4 votes in favour.
Taku Te Wheres.
1 vote in favour.
Maria Manu Kapakingi.
1 vote in favour.
The ayes are 55, the noes are 68. The question is not agreed. Ricardo Menendez March's tabled amendment deleting clauses 42 and 43 are ruled out of order as being inconsistent with a previous decision of the committee. The question is that Ricardo Menendez March's tabled amendments deleting clause 52 and 54 and subclause 4 of clause 36 be agreed to. All those in favour say aye. Aye. To the contrary, no. No. Noes have it. Please conduct a party vote.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
15 votes in favour.
Act New Zealand.
11 opposed.
New Zealand First.
Votes opposed.
Te Pāti Māori.
4 votes in favour.
Taku Te Wheres.
1 vote in favour.
Maria Manu Kapakingi.
1 vote in favour.
The ayes are 55, the noes are 68. The question is not agreed. The question is that Ricardo Mendes March tabled an amendment to clause 42.1 inserting for no more than 1 month and a new paragraph DA of section 324F be agreed to. All those in favour say aye. Aye. To the contrary, no. No. Noes have it. Please conduct a party vote.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes opposed.
Green Party of Aotearoa, New Zealand.
15 votes in favour.
Action New Zealand.
11 opposed.
New Zealand First.
It's opposed.
Te Pāti Māori.
4 votes in favour.
Taku Te Wharis.
1 vote in favour.
Maria Mino Kapakini.
1 vote in favour.
The ayes are 21, the noes are 102. The question is not agreed. The question is that Ricardo Menendez March tabled an amendment to clause 42.1 inserting if an adult in new paragraph DA of section 324F be agreed to. All those in favour say aye. Aye. To the contrary, no. No. Noes have it. Please conduct a party vote.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
15 votes in favour.
Action New Zealand.
11 opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
4 votes in favour.
Taku Te Wharis.
1 vote in favour.
Maria Mino Kapkingi.
1 vote in favour.
The ayes are 55, the noes are 68. The question is not agreed. The question is that Honourable Phil Twyford's tabled amendment to clause 42.1, new paragraph DB and DC be agreed to. All those in favour say aye. Aye. To the contrary, no. No. Noes have it. Please conduct a party vote.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
15 votes in favour.
Action New Zealand.
11 opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
4 votes in favour.
Taku Te Wharis.
1 vote in favour.
Maria Mino Kapkingi.
1 vote in favour.
The ayes are 55, the noes are 68. The question is not agreed. The question is that Venusi Walters tabled an amendment to clause 43, new section 324J3D be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The ayes have it. Party vote is called for. Please conduct a party vote.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
15 votes in favour.
Action New Zealand.
11 opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
4 votes in favour.
Taku Te Wharis.
1 vote in favour.
Maria Mino Kapkingi.
1 vote in favour.
The ayes are 55, the noes are 68. The question is not agreed. The question is that Honourable Phil Twyford's tabled amendment to clause 47, new section 351A1 be agreed to. All those in favour say aye. To the contrary, no. No. Noes have it. Please conduct a party vote.
New Zealand National.
49 opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
15 votes in favour.
Act New Zealand.
11 votes opposed.
New Zealand First.
Votes opposed.
Te Pāti Māori.
4 votes in favour.
Taku Te Wharis.
1 vote in favour.
Maria Mino Kapkingi.
1 vote in favour.
The ayes are 55, the noes are 68. The question is not agreed. The question is that Honourable Phil Twyford's tabled amendment to clause 48 to insert new subsection 8 be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. Please conduct a party vote.
New Zealand National.
49 opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
15 votes in favour.
Act New Zealand.
11 votes opposed.
New Zealand
8
First.
votes opposed.
Te Pāti Māori.
4 votes in favour.
Taku Te Wharis.
1 vote in favour.
Maria Mino Kapkingi.
1 vote in favour.
The ayes are 55, the noes are 68. The question is not agreed. The question is that Part 1 stand part. All those in favour say aye. Aye. To the contrary, no.
No. Yes, it's Part 1 as amended stand part. Pardon? You say Part 1 as amended.
Oh, it has been. Yeah, sorry, there has been an amendment. The question is that Part 1 as amended stand part. All those in favour say aye. Aye. To the contrary, no. No. The ayes have it. Party vote is called for. Please conduct a party vote.
New Zealand National.
49 votes in favour.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
15 votes opposed.
Act New Zealand.
11 votes in favour.
New Zealand First.
8 votes in favour.
Te Pāti Māori.
4 votes opposed.
Takuta Ferris.
1 vote opposed.
Mariamino Kapkingi.
1 vote opposed.
The ayes are 102, the noes are 21. The question is agreed. Members, we come now to Part 2, the debate on clauses 55 and 56, which are amendments relating to fiscal sustainability. The question is that Part 2 stand part. Dr. Lawrence Zunan.
Thank you, Mr. Chair. To start with, the Part 2 is equally important to Part 1 because it's actually half of the title of this bill, which is on the fiscal sustainability. My first question to the Minister is regarding actually the advice from, in a broader picture, the advice from the Regulations Review Committee, particularly when it comes to the levy setting component of this. Now, as you know, that in terms of how we look at levies and the difference between levies, fees, and tax, there are very specific criteria. So broadly speaking, considering some of the things that's going to be touched on in this bill, I wondered if the Minister would consider my amendment, which actually doesn't actually change much, but simply calling this section for what it is, that it's not actually a levy, but a bill. Yes, very good question. Thank you, Minister. It is 84035. So the reason I want to raise that as a sort of a broader thing, and then we can get into the details of it, is that the levies is usually used specifically for the operations of a particular agency in order for them to ensure that, there's checks and balances that all ends meet. But what we are seeing in this section, and I want to draw attention, and other people will be able to speak to some of the specifics. But for example, I want to draw the House's attention to the new 399AB, subsection 2A, which is for the operation of the public health and education system. Now, the other reason I'm asking the Minister's support on this for clarification between a levy and tax is levies is usually also within the general responsibility of the Minister in charge, which usually extends to a particular agency, but not so much in terms of what is being asked here. The Minister, for example, as far as I'm aware, the Minister may correct us that the Minister of Immigration, who oversees the levy and the immigration levy and Immigration New Zealand, is not the Minister who is in charge of the infrastructure required for or operation of the public health and education system. So it's a technical aspect. It's based on definition, but it's a very important definition in the general process, and this is something that I think, if you seek advice from the Auditor General and Controller, you'll find similar sort of similar advice in between levy, fee, and tax. So the first thing I want to ask the Minister is whether the Minister will support my amendment to change immigration levies to immigration taxes.
Mr. Chair.
Ingrid Leary.
Mr. Chair, I know that my colleague, the Honourable Phil Twyford, will have some questions regarding what this levy does specifically, because we do support it in terms of sharing the burden. But my very different question is what is not in Part 2 relating to the levy, based on the amendment paper that the Minister dropped today, because while we accept the changes around electronic monitoring, there are going to be additional costs to the immigration system. And as Lawrence Sunam has said, levies by definition have to relate specifically to the purpose that they are created for, and it's very clear in this bill that they are to fund education and health and to operationalise those. So that's very explicit, and it seems like this is quite a separate kind of immigration matter to what we've previously been speaking about, and yet we have had changes now, good changes made to the system regarding mass arrivals, where electronic monitoring, which is a fairly cost-effective way of dealing with people, will be limited. But we haven't heard anything from the Minister about what the risk mitigation will be for that and what the funding arrangements will be. And so when we're looking at the costings, the question I have for the Minister is whether she has conducted a cost-benefit impact assessment on the changes, including costs to immigration, now that she has tabled that amendment, because that's something that we have not had time to consider and wouldn't have been at select committee. And that's particularly with the restrictions to electronic monitoring, and considering also the additional costs to policing and other things that are going to happen as a result. They are very broad. They are definitely not the subject of what we would expect a levy for. But my question is, if we're going to look at the totality of the immigration system with these changes, is this the right vehicle? Should there be something in this bill which includes mass arrivals to indicate how the Minister is planning to pay for the fiscals on that, and also the affordability and the sources of revenue for the alternative methodologies now that we know that electronic monitoring won't be available? Just for those who are watching at home, we know that levies need to be certain, they need to be simple, they need to be neutral, and they need to be flexible, and certainly we can see that. And I know that my colleague, Honourable Phil Twyford, will have some questions around how they apply to the employment situation. But my broader question, if you like, is what is missing from this? Because the section itself does say amendments relating to fiscal sustainability, and I read that as meaning fiscal sustainability of the whole system. How are we going to pay for the mass arrivals changes previously, if not by a levy? And are we going to apply the tyranny of silos and put policing and other costs elsewhere? Or is there going to be a proper costing done that looks at the totality, and then how are we going to pay for those additional measures?
The Honourable Erica Stamford.
Well, the member kind of answered her own question in her speech. Essentially, as she rightly points out, we are broadening the levy base in immigration, because at the moment we only are able to levy the people who are applying for a visa. We are unable to apply levies to employers, for example, who are other people who get direct benefits from the immigration system, but who aren't contributing towards it. And so this is exactly what this part does. It broadens it out so that the things like the mass arrivals or the electronic monitoring or any other running of the immigration system, which is a defined cost and is set out, is able to be contributed to by a much broader base of people and not just the migrants themselves. That's an answer to that question. And an answer, or responding to Dr. Lawrence Jan, the levy sets out a finite set of purposes that the levy can be charged for to specific groups. This makes it not align with a tax, which is very broad. The provision is carefully drafted so that it is not a broad tax, but a very clear levy set out for a finite set of purposes.
Ricardo Menendez-March.
Thank you so much, Mr. Chair. We do have an amendment 23-2009, and this is in relationship to tightening what this levies can be used for, so that it is only for the for immigration system, which relates, and I wanted to understand if the Minister would be in support of it. I had some questions in relationship to 399AB on page 40 and on 2A, which is the intent of the wording in relationship to there's a note which at least, we don't support this, but at least it's good that the Minister has clarified that it's public health and education system, so public. But the language around infrastructure does not specify that it's public infrastructure, right? So can I just get the clarification of the intent that whether the Minister could foresee these levies being used to fund public-private partnerships, for example, and to contribute to the costs of those. And that is important because effectively, by not clarifying the types of infrastructure more broadly, and it leaves a bit of a sort of lack of clarity in the language of it. And I'm just concerned around the scope of just kind of keeping it so broad when it comes to the language of infrastructure. So clarification around that would be useful. The other question I had was in the Roman numeral 1 in relationship to that, which is in the specification of funding specialist teachers, school property, teacher training, or learning support. This makes an assumption that all migrants use the education system, but can I just ask whether, for example, if you've got a single adult coming here who may not be coming on a student visa, may just be choosing to work, may not be pursuing education at any point in their life, as to, whether they should also be required to pay a levy to contribute to the education system, or is it only the intent to then target specific visa holders that may be deemed to be using the education system more broadly? And so I would also begin my third question is in relationship to so 399AB 2B in relationship to employers. Now, what work has the Minister done or sought reassurances from industry bodies of employers that there may not be a level of, lowering of wage growth as a result of the provisions in here? Because I've seen that the Minister has obviously tweaked around some of the wage requirements for visa holders coming here, and not all actually visa holders have conditions on their visa that require them to be in jobs that they earn a specific amount of wage. Now, what reassurances can the Minister give us that employers may not use these provisions on B and as a result of them contributing levies to justify paying lower wages to migrant workers and therefore suppressing wages for migrant workers and locals more broadly as a result of those additional costs? If she's able to provide us some reassurances from industry bodies that this will not happen, that will be useful.
Mr. Chair.
Honourable Minister.
It is a requirement that employers are paying a wage that is commensurate with industry standards for the skill of the person who is being employed. So we in immigration and our immigration officers are always checking that. I would also note that we've just had a fee review where we've raised fees and not seen any evidence of the fact that employers are reducing wages to somehow make up for a small fee increase. But there is that inbuilt into the immigration system is when we are looking at an application for someone coming in the country who is, for example, going to be a painter and has a certain amount of experience and skill, we're always looking to make sure that they are being paid at a rate that is commensurate with their skill and experience. So there is something built into the system there, but we've not seen any evidence when we've done our fee reviews recently of increasing fees to employers of, for example, job checks or when we're asking people to be accredited, employers to be accredited, we've not seen any evidence. So I've not been provided with any evidence that wages have gone down as a result of that.
The Honourable Phil Twyford.
Chair, I think it's fair to say that Labor was intrigued by these provisions and we remain so, somewhat agnostic about them but willing to go along really in support of the principle that if costs can be spread more fairly, then all to the better. But I wanted to just ask the Minister's response to a number of submitters. I remember the Employers and Manufacturers Association particularly pointing out that the kinds of levies that one would anticipate from these provisions would very likely create the perception of double dipping by the government, seeking cost recovery through these new levies for things that are fully funded by tax revenue, including the taxes paid by existing migrants, without necessarily any expansion of services. And they also asked, I remember, they expressed the view that they would feel penalised for going to the cost and bother of recruiting someone on a temporary work visa from overseas, because the education system that is funded by our taxes here in New Zealand is not producing the kind of skilled workers that they need. So I asked the Minister to respond to that, and I think the implication of that question or that concern was that these levies, if not implemented in the right way, could really negatively affect the social licence and public support for the immigration program.
Mr. Chair, the Honourable Minister. Dealing with those two things, look, there are considerable costs that are borne by the system that are potentially not accounted for. Remembering that this is setting the ability to have additional levies on different people, like employers, doesn't necessarily mean that it will be done, and it means it will have to be a process of a fee and levy review and regulations. But I want to make the point that there are significant costs that fall on our system. And if you think about education, because I'm putting my other hat on for a moment, we have significant costs, for example, in learning support with migrants who have children who have additional learning support needs. Now, the amount of tax payable in the, say, 3 to 5 years that the person is here and potentially using services like teacher aides or speech language therapists or educational psychologists and the like, is something that we want to be able to consider accounting for in levies. And so these clauses are just giving us the ability to be able to consider that. I think Mr. Twyford probably answered his own question in the second part when he talked about the fact that the education system was potentially not providing the skilled workers that these employers were asking for. Part of this bill is actually saying, you know, we would like to be able to set or pay for, or have employers levied to directly pay for the upskilling of Kiwis into roles so that they don't have to employ migrants from overseas. But currently, they are enjoying the benefit of a skilled person from overseas, and the question here is whether or not we should be levying to make sure that we are able to fund education services to upskill New Zealanders into those roles.
Dr. Lawrence Zunard.
Mr. Chair. I want to continue, so I want to get into some of the specific clauses of Part 2, and I want to start with 55, Section 399, and 1, and specifically around 1C, education providers as a signatory provider within the meaning of Section 10. Now, I want to check with the Minister in terms of a couple of things. Number one, what is the revenue that MB is currently getting from export education levy already? And because, as the Minister would know, under the relevant regulations, signatories, those who are registered, are already being charged 0.8% of the levy for tuition fee for a student, and unregistered are being charged at 0.5%. I used to work for international school. I have to pay export education levies, EEL, every year all the time. Under this new requirement in terms of immigration levy, would then institutes who accept international students would be double levied? So the new immigration levy plus EEL. That's my first question on that. And I think that's an important clarification, particularly for schools that accept international students, private training establishments that accept international students, as well as tertiary institutes. In terms of what the other thing that the minister has said, and one of the things that we are noticing as well is schools, and the minister would may have an idea as well, that schools often do bring in international students in order to supplement their operational fund and be able to do more things for the schools and for all of their students. If they're being levied, and then the levy is being used as part of the education system, would the school have any guarantee that some of the levies that they were put towards will also come back to them, or it will be something that is more equally or evenly distributed to other ones? And my third question to the minister is around what the minister said before. I agree, in terms of you're going to have people here who potentially are on a work visa and with children who have additional needs, who may be using learning access or a variety of forms of learning access. But just want to check with the minister, surely that if you're here and you're working, you're paying taxes anyway, and people who are paying taxes as PAYE are already contributing towards the kind of core facilities and infrastructure that as a tax-paying person will be eligible for. Therefore, their child, regardless of whether they have additional levy or not, should be able to access the same thing as anyone else who pays the same amount of tax, because it's not like people here who are on a work visa are paying lower tax than people who are permanent residents or etc. So I just want to check what the minister means when the minister has just referred to those additional things. Or if the minister can give examples of people who are here who are not paying taxes that contributes towards the public health or education system.
Mr. Chair. Mr. Chair. So number 6 within the 399AB, this is the one that allows the minister to, by special direction, exempt any person or class of persons from the obligation to pay all or part of the levy and refund or part of a levy. Now, can the minister please reassure us that her intention is not to include applicants of the Migrant Exploitation Protection Visa when it comes to this levy, or people who are applying for the family violence visa as well as part of this levy. Now, there are some visas that people have to access as a result of, well, tragedy and hardship that people experience. And I think that the powers that this levy grants the minister are pretty broad. And I don't remember her giving us explicit clarification and reassurances that for some of those visas that are for people who are finding themselves in particularly vulnerable situations, that they will be exempt from having to contribute to those. So, because I noted that this is a line that could allow the minister to basically exempt people and part of these powers, like I think it would be good for the minister right now to give us that reassurance in relationship to the powers that the minister is given. Now, one of the subsequent questions, following up on my colleague Dr. Lawrence's Sunan, is also whether as part of the signing of this part, whether she sought advice to allow her to have a picture as to whether migrants in the medium term are basically, whether their contributions towards, through tax, towards education and health are greater than the resources they utilize. I have seen some documents showing that migrants are actually net contributors to the tax base due to the fact that they can't access things like welfare, things like other public services while they are working. And so the reason why I ask this is because it is concerning to be building this narrative that somehow migrants, compared to the general population, utilize or extract more resources from the public systems, as opposed to what we have seen in some papers in relationship to migrants actually contributing to a greater degree to the tax base than they take as a result of the utilization of public services. Because then, to me, that puts into question the justification in this narrative that we have heard that somehow migrants require need to contribute an additional level of resourcing for these systems. So whether she sought any advice or analysis on the kind of contribution versus intake of public services from migrants. And the second question, which I referred to earlier, is which groups of visas has she already preemptively has chosen to exclude, for example, migrant exploitation protection visa or people who are experiencing family violence?
Mr. Chair. The Honourable Minister.
Right, Mr. Chair, just running through that. Currently exempt from levies people who are applying for domestic violence visas, refugees and migrant exploitation visas. These exemptions already exist currently for levies, and as we work through the fee and levy review and go through the regulations, then further exemptions would be considered at that time, and that's what the bill sets up. That ability to do. I just want to make it really clear that MB doesn't receive any of the export education levy. It is for a completely different purpose under a different act, and it is, as I think the member knows, for quite a different separate purpose, not for helping to contribute to the costs and broadening the base and contributing to the costs of running the immigration system. And the second part of this, the levy that we are considering and putting the vehicle into this bill, if we were to levy for different purposes outside of what we do now, like health or education, for example, the levy must fund specific purposes like specialist teachers, teacher training or learning support, for example. And just to the previous member's point, we already, under the Immigration Act and under the levy, have the ability to levy for things like ESOL funding. So we already do that because we acknowledge that it is a direct cost mostly borne out by migrants. But what we're acknowledging in this bill is that there are more costs that are directly or should be directly payable to a proportion through a levy by migrants, and that is because they are here for a shorter period of time, and as I've already mentioned, they must be for specific purposes that are directly linked to those people, and that's why it's very clearly set out that there has to be a relationship there.
Ingrid Leary.
Really appreciating the Minister's engagement with these quite important questions. I have to put it on the record that I was approached by the international students at Otago University about a year and a half ago who are really concerned at the jump in fees for them to be able to study at Otago. So while we cautiously support this idea of spreading the fee load, I'm concerned that we might end up with a two-tier system where we have employers who are able to afford and support students, or if students are in a particularly advantaged situation, because it is clear that somehow their fees will be more affordable, whereas other students will not be able to do that. So just seeking an assurance really that we're not going to be creating subclasses of migrants who are really feeling the pinch from these fees and levies. And I do, well, they're levies and they pay university fees. I do take the Minister's point that there are costs involved with manakiing people into New Zealand. The Minister herself brought into the debate and talked about the fact that the wider costings borne by the immigration system are not captured within this. And we do have, Mr Chair, the wording section 2, fiscal sustainability. What we haven't seen or heard from is from the Minister is what the fiscals are for the new mass arrivals regime. I am sure, given the duration of time that this has been considered across Parliament, including by ministers under the previous Labor government, setting up what a mass arrivals scheme would look like and the impact of that on immigration, on airport operational capacity, on the cultural training and safety that might be needed for enforcement officers, for the ability to use information and data to track the 24-hour time frame to see whether there is something that qualifies as a mass arrival, and then also there's processes needed to be able to efficiently deal with people if there were, I think, 30 something people coming in at one time. there must be costings on that, and I'd really like to know from the Minister, since she did raise herself that this is a broader systems cost that is not contained in the levy. It would be good to know what the cost to the taxpayer is. I really appreciate the fact it's not going to be pushed into this levy and that we're not suddenly seeing an expansion of powers that extend it from operationalising health and education and then going to mass arrivals, but she has talked about broadening it further. We don't really know what that broadening means. The Minister has talked about particular educational things that might be included, but there must be some specificity, I think, and I know the Minister draws on education because she has that portfolio and knowledge, and also immigration, but I'm really curious to know, and for the Hansard, what does she foresee as the benefit of broadening those powers? And then secondly, where are the fiscals, or can she share with this House the costs of the mass arrivals? I'm assuming that the cost of doing this well is going to be ultimately a huge cost savings for taxpayers. But I will remind you, Mr Chair, that the Minister did mention that herself, and that's why I'm asking, because under Section 2, when we're talking about sustainability, we've got this wedged into two very kind of different parts of an immigration question. We want to take a systems approach, and it would be good to understand the fiscals for both of them.
Honourable Minister.
It's a very nice try from the member, but she raised mass arrivals, not me, and I made the very broad point that in order to run the immigration system, we need to levy, and there will be costs that fall, and in the fee and levy review and in the regulations that we set, those will be taken into account. It's actually irrelevant to Part 2. Also, if the member wants to know the direct benefits of the proposed level, I suggest she looks at level at 399AB, extended immigration levy, because it's laid out in point 2 quite clearly.
Carl Bates.
Now close.
Ricardo Menendez-March.
Much, Mr. Chair. So I had a question in relationship to the provisions in 399AC, which we haven't touched on yet. Now, this is in relationship that before making any recommended regulations for the purposes of Section 399AB, which we've canvassed, the Minister must consult with any persons or organisations the Minister considers appropriate. Now, I understand that obviously this is left broad enough for any minister of any government to do this consultation, but has the Minister already set out or sought advice on who does she foresee will be the organisations and the people that she intends to consult with? And would she be able to give some clarity and put it on the record, the range of bodies that she will look to consult? So, for example, will unions be part of that? Which industry bodies will she be prioritising? And when it comes to persons, is it going to be sort of like immigration lawyer experts, etc.? I think some clarity over that would be useful. I think particularly in the context of, I think, the public trust being tested in relationship to who governments choose to consult with in relationship to policy design, I think it would be good to put it on the record. If she hasn't done any work in relationship to the provisions of 399AC, hasn't lined up any organisations of people, I can accept that, and it would be good to have that clarified as well. And I wanted to ask whether or why there aren't any, by the looks of it, any reporting requirements or to sort of in relationship to, I know that potentially we could get them through official information at request, but just reporting requirements on who she is consulting with and kind of a bit of an explanation as to why she may have included some organisations and bodies compared to others. And so just keen to also get the Minister's clarification on this. I wanted to, following up the previous engagement, and I thank the Minister around her engagement on the sort of exclusion of some of the visa categories that are specifically vulnerable people. She did not necessarily give a commitment that some of these visas would be excluded. It's just something that would be looked at into, which takes me to my colleagues' Dr. Lawrence Hunan's amendment 84036. Which specifies victims of family violence residency visa, refugee family support resident visa, dependent child resident visa, trafficking victim residency visa, any other refugee vulnerable protected person visa categories. Now, I know that the Minister already talked about the interactions with some of the other regulation-making powers that exist in the current legislation that we have, but without giving us an explicit reassurance that some of these visas will be excluded right now, it's hard for us to have faith that some of these won't be captured. So we're happy to rescind that amendment if the Minister is able to give us that reassurance that those visas won't be captured, as opposed to just letting us know that she'll look at it at some point, because I don't think that gives certainty to people who often are in extremely precarious situations that they may not be burdened by additional costs. I particularly raise this because, for people in the migrant exploitation protection visa, even just the cost of applying for those visas can be a bit of a barrier. And I think that's additional costs through this levy could end up becoming a disincentive for people to report exploitation if they know that they could be burdened with additional costs. Finally, my other question is in relationship to how the Minister would foresee decisions on how the funding that is acquired through the levy would be distributed between infrastructure, public health, and education. And I particularly wanted to seek guidance from the Minister and clarification as to whether she would see the distribution of those funds between those three entities that are noted as part of a sort of just budget process, or whether she's got any sort of clarification as to how she foresees those three bodies that are being named in terms of decision making when it comes to the distribution of those three. So I would appreciate the Minister's engagement, but particularly the one I care the most about is the one on 399AC, which we haven't touched on.
Carl Bates.
Debate on this question now close.
Ingrid Leary.
And a very quick question from me, Mr. Chair, a new point which is really around section 399AC, where we can see that in subsection 2 that at intervals of no more than 5 years following the commencement of the section, the Department must review the amount and method of calculation of any extended immigration levy. I'm keen to understand why it's 5 years. I know that's quite an ordinary drafting time frame. However, it's a pretty fluid situation at the moment with the cost of living. We have seen big rises in immigration fees, as I've mentioned, from international students who are really concerned. Would it be fairer to reduce that amount and make it annual or perhaps every 2 years, especially taking into account the impact of the levy on those who are applying for visas? We don't see any weighting in the way the bill is currently drafted that really prioritises them, and therefore there is a real risk that these levies, with the increasing cost of living, the rules just roll over. They're not fit for purpose for the context. Would it be useful for the Minister to consider a shorter time frame, and did she actually consider other time frames, or was this just put into the bill because it happens to reflect something that already existed in the previous bill?
Mr. Chair.
The Honourable Minister.
In relation to that last part, it's not in scope. It's not in scope of the bill, so it wasn't something that we considered. Can I just answer the questions relating to the previous speaker? Firstly, in terms of what MB collects and spends in terms of those levies, it will be reported on exactly what is collected and then how the money is distributed. So there is accountability in the system. I just want to make the point that the migrant exploitation visa is free. There are no costs for it. And so the member is concerned that it might increase by a certain percentage. It's a free visa. But I have already made the point that any extensions to the levy base will be considered through regulations and in the fee and levy review. But all of those things are currently exempted. Now, in terms of the 399AC that the member talked about, I mean, essentially the people who we are going to consult, as you would expect, are the people who are affected, and it will be made public by Immigration New Zealand, who has been consulted with.
Vanessa Winnick.
This question now close.
Dr. Lawrence Sunan.
Thank you, Mr. Chair. I actually have a really short question, and if the Minister would just nod, that is sufficient for me. Thank you to the Minister for responding to the question around export education levy. But one of the things we didn't hear from the Minister is, does that mean that education provider will be double levied, one for education export levy and one for this? That's all.
Speaker, they're two completely different levies. One is in a completely different act and is for a completely different purpose. It is essentially an insurance scheme for when an education provider falls over, and to protect our reputation, we pay back the fees of the impacted students. It is a completely separate thing in a completely different act, and the member shouldn't conflate the two. This is a completely different proposal to broaden the levy base to people who are benefiting from the immigration system, like export education providers and like employers who currently might pay a fee like an employer but do not pay levy. Now, if we want to broaden this and have a more fair system, and in answer to previous questions, maybe reduce the levies that we currently levy on migrants, then we need to have a broader base. And it is fair and reasonable to expect that people who are benefiting from the immigration system should be equally charged a levy so that they can essentially pay for the benefits that they are currently getting but are not contributing towards.
The question is that Ricardo Menendez March's tabled amendment deleting clause 55 be agreed to. All those in favour say aye. Aye. To the contrary, no. Aye. Noes have it. Party vote is called for. Please conduct a party vote.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
15 votes in favour.
ACT New Zealand.
11 votes opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
4 votes in favour.
Te Kuta Ferris.
1 vote in favour.
Mariamino Kapakingi.
1 vote in favour.
The ayes are 55, the noes are 68. The question is not agreed. The question is that Dr Lawrence Unan's tabled amendment to clause 55 and 56 be agreed to. All those in favour say aye. Aye. To the contrary, no. No. Noes have it. Please conduct a party vote.
New Zealand National.
49 opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
15 votes in favour.
ACT New Zealand.
11 votes opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
4 votes in favour.
Takuta Ferris.
1 vote in favour.
Mariamino Kapakingi.
1 vote in favour.
The ayes are 55, the noes are 68. The question is not agreed. The question is that Venushi Walter's tabled amendment to clause 56, new section 399AA be agreed to. All those in favour say aye. Aye. To the contrary, no. No. Noes have it. Please conduct a party vote.
New Zealand National.
Opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
15 votes in favour.
ACT New Zealand.
11 votes opposed.
New Zealand
8
First.
votes opposed.
Te Pāti Māori.
4 votes in favour.
Takuta Ferris.
1 vote in favour.
Mariamino Kapakingi.
1 vote in favour.
The ayes are 55, the noes are 68. The question is not agreed. The question is Ricardo Menendez March's tabled amendments to clause 56, amending the heading and deleting new section 399AB, 399AC be agreed to. All those in favour say aye. Aye. To the contrary, no. No. Noes have it. Please conduct a party vote.
New Zealand National.
49 opposed.
New Zealand Labour.
34 votes opposed.
Green Party of Aotearoa, New Zealand.
15 votes in favour.
ACT New Zealand.
11 votes opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
4 votes in favour.
Takuta Ferris.
1 vote in favour.
Mariamino Kapakingi.
1 vote in favour.
The ayes are 21, the noes are 102. The question is not agreed. The question is Ricardo Mendes March tabled amendment to clause 56, new section 399AB2A be agreed to. All those in favour say aye. Chair, the contrary, no. Noes have it. Please conduct a party vote.
New Zealand National.
49 opposed.
New Zealand Labour.
34 votes opposed.
Green Party of Aotearoa, New Zealand.
15 votes in favour.
ACT New Zealand.
11 votes opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
4 votes in favour.
Takuta Ferris.
1 vote in favour.
Mariamino Kapakingi.
1 vote in favour.
The ayes are 21, the noes are 102. The question is not agreed. The question is that Dr Lawrence Unan's tabled amendment to clause 56, new section 399AB, inserting new subsection 4A, be agreed to. All those in favour say aye. To the contrary, no. Noes have it. Please conduct a party vote.
New Zealand National.
49 opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
15 votes in favour.
ACT New Zealand.
11 votes opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
4 votes in favour.
Takuta Ferris.
1 vote in favour.
Mariamino Kapakingi.
1 vote in favour.
The ayes are 55, the noes are 68. The question is not agreed. The question is that Benushi Walters tabled amendment to clause 56, new section 399AB8, inserting new paragraphs C and D be agreed to. All those in favour say aye. To the contrary, no. Noes have it. Please conduct a party vote.
New Zealand National.
49 opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
15 votes in favour.
ACT New Zealand.
11 votes opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
4 votes in favour.
Takuta Ferris.
1 vote in favour.
Mariamino Kapakingi.
1 vote in favour.
The ayes are 55, the noes are 68. The question is not agreed. The question is that Honourable Phil Twyford's tabled amendment to clause 56, new section 399AB, to insert new subsection 10 be agreed to. All those in favour say aye. To the contrary, no. Noes have it. Please conduct a party vote.
New Zealand National.
49 opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
15 votes in favour.
ACT New Zealand.
11 votes opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
4 votes in favour.
Takuta Ferris.
1 vote in favour.
Mariamino Kapakingi.
1 vote in favour.
The ayes are 55, the noes are 68. The question is not agreed. The question is that part 2 stand part. All those in favour say aye. To the contrary, no. The noes have it. Party vote is called for. Please conduct a party vote.
New Zealand National.
49 votes in favour.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
15 votes opposed.
ACT New Zealand.
11 votes in favour.
New Zealand First.
In favour.
Te Pāti Māori.
4 votes opposed.
Takuta Ferris.
1 vote opposed.
Mariamino Kapakingi.
1 vote opposed.
The ayes are 102, the noes are 21. The question is agreed.
Correct.
All right, the time has come for me to leave the chair for the lunch break. The House will resume at 2 p.m.